Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on kids. Dati mihi Anglican parade.
Is that correct?
Oh, for crumb's sake.
So, how would you like me to proceed here?
What are the charges? Again, all the ones that...
Well, right now you're not doing a very good job of representing yourself because you don't even know what you're charged with. Let me tell you again.
All right, I got the sound effects to work, but I broke everything else. Welcome back to the Court of Public Opinion. I'm the Recovery Addict. All right, it's all right. It's all good. I was just, I was almost late. I was almost late because I was listening to Judge Wolf. Judge Wolf has a sob sit who, in front of the jury, changed his plea to guilty. He's like, Judge, I'd like to change my plea to guilty. Anyway, it's always good. It's always good. All right, welcome back. Welcome back. You watch Court with us. I'm always watching Court. I'm always. It's like I have eyes everywhere. Eyes everywhere.
I was told counsel wanted to see me at sidebar.
Sidebar. Welcome back.
Taking it easy.
Let's see if I can get this to play.
Ladies and gentlemen, I've given you a set of instructions that have a
Nope, that's not it. Let's see.
bring the jury.
Why did I? You don't want it to be day 3? Day 2. That means I changed the last one wrong. I'm pretty sure somebody had day 3 on the pinned message, and so I copied that. My bad. All right. Stacy, always needing the verdict music. Welcome. Let's see if we can get some chat on screen. Kim R., congratulations, first in chat today, as you've been first in chat many, many days. I'm not going to give you the full speech, but you know the punishment is squarely on your shoulders. It's yours. It's not our problem anymore. Fix the internet. I saw day 3. I saw it. All right. Thanks to my wife. Came out of the studio here at lunchtime, and she's like, "Hey, Scott, I've got lunch," and it was ready, hot out of the oven. She made some roast potatoes, like the mini potatoes. Some good stuff. It is day 3, says by me. It is day 3. Amber, did I do it wrong? Josh, did I do it wrong? She doesn't call me RA. No. She... Funny thing, she doesn't. She knew me before. Is it day 2 or day 3 today of the sentencing phase? It's day 2. So Monday, no court, right? Tuesday, no court. Wednesday, it's day 2. It's day 2. Okay, we've got it. It was Wednesday and Thursday. Those are the 2 days we've got. All right, it's all good. It's all good. Gadget Girl, look at you. You found the button. It says, "Yay, thanks for the help. I celebrated 11 months with a Prison Escape hoodie and a sticker. Love this channel. I've been here since Brooks. That makes you an OG." Gadget Girl, thank you very much for 11 months of support on the channel. That is awesome. And thank you. I did see a couple of you picked up hoodies, so I can't wait to see your Halloween pictures. And let me just say, yes, it could potentially get you into a little bit of trouble, but it will be cleared up right away, and you'll probably never even have to get arraigned. So there's that. Let's see. Morning Stream says part 3. That's because I put it there. I broke it. I had part 2, and then I said, oh, I saw 3 somewhere, and I'm like, it must be 3. So, sorry. I perpetuate that information. Death penalty is majority vote of jurors. No, it's 8. 8-4, 4 against is the minimum to get death penalty as the recommendation. So it's 8-4. That's the objection that the defense put on the record, saying in case we haven't already. Yeah, good stuff. In case we haven't already, we'd like to file our objection because I believe the Supreme Court has not ruled on Florida's 8-4 death penalty standard yet. And you're like, why? It's sort of a big deal. Why haven't they like jumped on that? Be like, hey, let's get that addressed. It hasn't been around that long, and so for somebody to work through the appeals process and get up to the Supreme Court, it takes years. And so we still are convicting people with the 8-4 rule, and then all of those might be reversed, or might have to go back to sentencing later on. All right. Let's see. I keep thinking today was going to be Friday. Very disappointed when it wasn't. Curly Q NPR. You can always come to the podcast tonight at 8 p.m. and celebrate the Friday Eve with us. It was changed after Nicholas Cruz's jury. Yeah, it's very recent. So nobody has been executed in Florida who was convicted using the 8-4 rule. And basically, the first person for that to be an issue on is going to be the case that's most likely the one that takes it to the Supreme Court, and they rule on it and say whether it's good or bad. So we'll see how that happens. Where do I find the Halloween hoodie? Amber's the only one I know who has the link. Amber, can you post the link again? You have to click on it when it pops up in chat for the Prison Escape hoodie, which is in Halloween orange or prison orange, depending on how you view things. All right, there it is. Quick, click on it. Do we have... Why is that not like a command, Amber? Have you not done that? I'm sorry, is that my job? Yes, it is. I have not done that. It's my fault. Hoodie? I think there is one somewhere. There's a command for like uniform or something. Doesn't uniform do that?
You don't put a diplomatic plate on a hoodie.
Doesn't uniform work? Let's see. Here we go. Here's uniform. Wait for it. Boom. Booyah. Let me see what that link goes to, actually. It's like I already made it, Amber.
Ash, I'm trying to have court. Don't raise your voice again.
You have to scroll through a little bit, I think, to find it. But let's see. I can't see the...
There's nothing in the order that restrains you.
That's
from
just the
to
seat
cats.
one. Got a few things on there.
I think I'm about the cat. Are we going to address subject matter jurisdiction?
Okay. Oh, if you click on that link and then you click on apparel, then it goes back, and you can find the Prison Escape hoodie. You even have it a zipper version, but not orange. Good stuff.
In front of the Walmart.
All right. Hang on, I'm getting back to where we were. Hang on. Where's chat? Chat disappeared. All right, chat's back on the screen.
Back on the record, all parties present, not the jury.
All parties, but not the jury.
Judge, I realized during lunch that we missed a mitigator in our list, and the mitigator is kind of the catch-all provision under subsection H. So I'd like to modify the list to add at the end of the list the existence of any other. It says factors, but I think we should be consistent with the language and go with the circumstance or circumstances in the defendant's background or any other circumstance that would mitigate against imposition of the death penalty.
I think that's in the instructions already, isn't it?
It is, Judge, but it's not in the mitigating list that we're going to send back to the jury.
Is the statutory mitigator on there? It's on there twice.
It was the Middleton audio that I played earlier. This one.
So, how would you like me to proceed here?
This is the one.
On page 3, the existence of any other factors in Jose Soto-Escalera's character, background, or life or the circumstances of the offense. So you don't think that suffices? You want to add something to it?
Wants to have it on the list.
Oh, I think if you have it, it's in the main instructions, and in your argument, you could just say number 2 is everything else that we're requesting. You're going to have a list at the back of the instructions just to refer to.
Okay.
So it's meant to incorporate that. That's why I put the parentheses next to it.
Yes, sir.
Saying a list is attached here to for your reference. And I'm going to tell them that. I'll read them. A list is attached here to for your reference regarding the defendant's proposed mitigating circumstances.
Yes, sir.
And I'm sure you're going to refer to that in your closing argument.
And then the other thing we talked about was, and Mr. Burns, I don't recall, but I don't know if you put it in front of the jury that he doesn't have a significant criminal history, and that we agreed to that. Did we do that stipulation to them?
Well, I think in the absence of the stipulation, it's sort of proof by non-proof.
We do agree to it.
Right.
We want him to put it in.
That's what I think.
I think you could just argue it
Yes,
that the
the
state's
way
not
it's
contesting the existence of that.
What you're indicating, I think, is the way it will play out is it will not be argued, and then I'll say they didn't argue, it's not proven.
Right. Meaning the jury's going to think, well, if he had something, they would have.
We just don't want it to be an issue later that it didn't get presented during the evidence.
Yeah, I agree with the state, Judge. I think it's cleaner if we just do a formal stipulation that you read, that both sides have rested, but I need to instruct you that both sides have stipulated at this point. Because even if Mr. Burns argues it in his closing, the jury could still decide that we didn't put on any evidence of it because we didn't, and not find that as a mitigator, even though the state's agreeing to it and not arguing against it.
Let me propose this. I'll give them an instruction.
We're not talking about his reported confession that caught on video at work about a previous murder.
I would tell them before the arguments begin, the parties agree or stipulate that the defendant has no significant history of prior criminal activity. And that sets us up well. That's even before the arguments, and then when they get the instructions, they'll hear that as the mitigator. They'll know it's stipulated or proven. It sounded like they were coming through the hall in the back. Is that what I heard? All of the jurors out?
It's a juror stampede in the back hall.
One's in the restroom.
Why are you letting them go? Never mind. I have to run a teleprompter this weekend. This is my teleprompter. I load the files in here on an SD card, and then I can put this up on this whatever screen I choose and just scroll through the words. If my hand shakes, though, it goes. This is actually a video recorder. Meant to record video and play it back, but it doesn't have a screen on it. It does work as a video recorder, but it works better as a teleprompter. It's pretty smooth that way. I can make people say anything I want with this machine, honestly. Once people get in the habit of reading a teleprompter, you put the words in front of them and they will read it. It's great. It's a lot of fun. It's great power. There's a movie about that. Ron Burgundy. Anchorman. Escalated quickly. I've got to load all the scripts up tonight. Yeah, Greeners, this is pretty much it. That's how it goes down. Stay classy, all right. Yeah, Josh, I heard that. He's count 1 was the driving without a license or something, and count 2 was like assaulting an officer, something like that. So he pleads not guilty to assaulting the officer and guilty to driving without a license. Can his cousins visit him while they're in town? I imagine he's being held at the courthouse today, and the courthouse probably does not have visiting facilities. Were he back in jail, he could probably use regular visiting hours, but I just don't think he can do that right now. Looks like our witnesses are back supporting Jose, or Jozo, as the judge calls him, including Mom. Murder show, that's awesome. That's awesome. Congratulations. You got my number. I'm not the best tech help, but I'm free. So, you know, there's that. I think we're coming in now. Nope, that's somebody else. Yep.
Jury is entering.
I don't think they are. Oh, yep, they are. They're coming in. There we go.
All right. Members of the jury, we are about to conclude the case with the arguments by the attorneys. Before we do, the evidence is closed. However, I do want to instruct you that the parties agree or stipulate that the defendant in this case has no significant history of prior criminal activity. So The lawyers are about to argue the case to you. As I mentioned, the evidence is closed. What the attorneys say is not evidence, but do listen closely to their arguments. They are meant to persuade you in your evaluation of the evidence and influence your decision from their perspective. Both sides will have an opportunity to make an argument to you, but the state is allowed to proceed first, and the state may proceed with its closing argument.
Think back again, all the way back to jury selection these many weeks ago, right? And we had talked about our ability to keep our word and follow the law, right? That's what we're here for. That's what we're here to do. We remind you again at the last closing argument, and I'm going to keep beating that drum, right? Because it's so important to be able to follow the law and to keep our word, particularly in a case such as this with the evidence that's been before you. When you do that, always view this evidence through the lens of objectivity, and to make sure that we render a dispassionate verdict, right? You've been confronted with highly emotional evidence from both sides, right? And that's why it's important to view this evidence as dispassionately and as methodically as we can so that we arrive at the correct decision. Emotional people make bad decisions, right? Emotional people make bad decisions. That's why we've got to look at this evidence with objectivity, reason, and logic, right? So, having said that, this is what we're confronted with today. And again, I'm going to kind of go through this process again. I know we've heard it before, but we want to make sure that we get it right. So, to be clear, you are confronted with not one death sentence, but two, right? 2 death sentences are on the table, 1 per count. Count 1 deals with the murder of Tanya, count 2 with the murder of Josiah. Each count is analyzed separately, and we use the same process that's been set forth in the jury instructions that was detailed to you by Judge Murray. Of course, the first step is we got to have a unanimous finding that the state proved at least 1 or more aggravating factors per count in order to proceed with the death penalty. Those have to be proven beyond a reasonable doubt, right? And in this case, both counts share the same 3 aggravating factors. The same 3, and then there's an additional aggravating factor for count 2 that deals with Josiah. So here they are. The first one, the defendant was contemporaneously convicted of another capital felony, right? Contemporaneously or at the same time. The murder was committed for financial gain. There's your second aggravator. The first-degree murder was committed in a cold, calculated, and premeditated manner without pretense of moral or legal justification. Right? Those are our 3 aggravators that are shared by both counts. Count 2, in which Josiah is the identified victim. And this one is this. The victim of the first-degree murder was under the age of 12. That's it. And so we'll start with the easiest one first, right? The first aggravator, this should be unanimous, is this one. The victim of the first-degree murder was a person less than the age of 12. Well, what's our evidence to support that? Well, of course, it's straightforward, right? Tanya was pregnant. She was very far along into her pregnancy. We presented the testimony of Dr. Stossel, and what did Dr. Stossel say? Do you remember? He said, listen, this was a perfectly healthy child. Mom had some complications, and mom was high risk, but that child was perfectly healthy. So there's your unanimous aggravator, at least for count 2. Then we go through the remaining aggravators and that apply to each count. So the first one, the defendant was contemporaneously convicted of another capital felony. Well, that's what we have here. This aggravator applies to each count because the homicides occurred at the same time, contemporaneous, at the same time. The count 2 would be an aggravator for count 1, and vice versa. Count 1 would be an aggravator for count 2. So this has already been proven, and it's reflected in your first verdict. Next, the first-degree murder was committed for financial gain. Okay, let's talk about this. So in the transcript, session 3 of 39, you heard the evidence. This is the words of the defendant. She's pregnant from that little a-hole that works there. She says it's mine, supposedly. I can't take any chances. I lose everything. I'm going to blow her brains out so that she doesn't talk. I have to do it, Eric. I have no other choice. And then key sentence, I am going to lose everything. I am going to lose everything. And then he follows that up. If my wife found something like that out, oh my God, bro, I lose everything, bro. So there is our aggravator. So how do we arrive at financial gain from those particular circumstances or from those particular statements? I'm going to lose everything. We all know what the consequences are of a possible divorce, right? That's what he's looking at in his mind. He's looking at possible divorce. So what does that mean when he says, I'm going to lose everything? Well, first off, as we all know, just from common human experience, what happens? You get a divorce, your cost of living increase, you no longer have a second income. Remember, his wife is working with him at Waste Pro, right? His wife works with him at Waste Pro at the time of this, right? So we have that, and we also have, what do we have? Child support, right? This is his way out of paying child support. Now, it's important to keep in mind, this financial gain, it doesn't have to be the primary motive for this killing. Let me be very clear about that. This does not have to be the primary motive for this killing. It can be a motive for this killing. And that's the state's position in this case. It is a motive, not necessarily the primary motive. And it's borne out by this defendant's own statements. It's borne out by his own statements. I'm going to lose everything. That means his wife. That means financial, his ability to prosper financially. That means he can avoid child support. That's what that means. And that's the aggravator in that particular case. Next one. And the most significant, right? The capital felony was a homicide and was committed in a cold, calculated, premeditated manner without any pretense of moral or legal justification. Okay, here we go. Remember, and the jury instructions define it. What happens is it defines each subpart, right? Cold, calculated, premeditated. I'm going to walk you through each one of them. Cold, this is what the jury instructions say. It means the murder was the product of cool and calm reflection, right? Cool and calm reflection. What's our evidence that supports that definition? Well, here it is. 2 days prior to the murder. The murder happened on August 23rd of 2018. This statement was made on August 21st of 2018. Listen and think about what he says here. I just can't do it inside my truck. It won't hurt me if it's not my truck. I got to strangle that bee. You can't leave no blood or nothing in the truck. I don't want nothing. If they ever come asking about anything, there's nothing. It's like you said, there's no other way around it. It's like you said, you got 2 unintelligible and that's it. All the BS will be over, and the higher up around here, the more they'll blame her boyfriend. Because they're always fighting, you know what I'm saying? She now has a record in which someone did something to her. You know what I'm saying, all that S. So think about what he's talking about here. He's already developed a plan as to how he's going to kill her. He's already developed a plan as to how he's going to execute. I said her, it's both of them, right? As to how he's going to execute both of them. This is his plan, and he's smart enough to know I can't do it inside my truck, right? Because And he's trying to figure out a way to not leave blood. I got to strangle that bee, right? So he's coming up and he's developing this plan, and it's with an eye towards avoiding detection, right? He's minimizing his risk. He's trying to get away with this, right? So I can't leave no blood. Of course, the best laid plans of mice and men, right? He did leave blood in the truck. He did leave blood in the truck. But 2 days beforehand, his plan is to get away with a double homicide. So, think about what he's saying here.
Welcome, Cupcakes. Thank you very much, Melanie Little.
In the
Appreciate
higher up
the raid.
around
Welcome,
here,
everybody.
presumably he means law enforcement. The more they'll blame her boyfriend, right? The more they'll blame her boyfriend because they're always fighting. You know what I'm saying? She has a record in which someone did something to her, meaning that the law enforcement will look and find out cases in which she's been a past victim, and then they'll point the finger at him. Right? Think about that. So not only has he developed a plan to execute Tanya and Josiah, but his plan is more in depth than that. His plan is more devious than that. What does he do? He is attempting to frame this so that someone else can be blamed for the murder.
This is closing arguments
Right?
for the sentencing phase.
Someone else, an innocent person, can be blamed for these murders. That was his plan. That was his plan. Not only to execute these people, but to get away with it. And third, to make sure an innocent person was convicted in his stead.
I've got to turn him down. He's yelling at us.
Extreme facts call for an extreme sentence. Extreme facts call for an extreme sentence. Was all of this, the questions before you was all of this, is that the product of cool and calm reflection? Absolutely it was. Absolutely it was. Calculated. Calculated means having a careful plan or prearranged design to commit murder. Okay, so what are our facts that support that particular sub-element? Well, again, 2 days prior to the murders, he's in this waste pro truck and they're driving around with Eric Alvarado. And what does he say? You can't prove anything if no one saw anything. I was thinking of taking her to some field nearby the route. Adolfo Cavelli testified the scene of the crime was on his trash route, right? So his plan, he was able to execute his plan, right? So he took her to a place near the trash route. Do you know where I go? When she go in there, she disappears for a couple of days. She does that. She disappears for 2 or 3 days. She always does that. And I'll take her phone and I'll throw it away. I'll throw it away or I'll burn it. They can't do anything there. I have everything planned out. This was not, ladies and gentlemen, a homicide or homicides that was committed in at the spur of the moment, in the heat of passion, when someone's upset, when somebody wasn't thinking through the consequences of his actions. Oh no, he admitted, he stated, he had everything planned out. Extreme facts call for an extreme punishment. And premeditated. The third sub-element. Remember, this is exactly what you've already found. This portion of the jury instructions, it's no different than what you found during the guilt phase. It defines premeditation. What is added on in this phase is this particular section right here. For this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. So that's the difference. That's the difference for the aggravator. The aggravator adds on this requirement of demonstrated by a substantial period of reflection. So what we have is we've already gone through statements where he's made 2 days in advance about how he's planned it out. right? 2 days in advance, he's planned it out. But do you remember, think back to Kenneth Barron during the guilt phase, right? Kenneth Barron was the guy, he comes in and he says, listen, this defendant approached me about a ghost gun, right? He approached me about a ghost gun. And when did he do it? 2 to 4 weeks before, right? 2 to 4 weeks before. If he's to be believed, and we have no reason to disbelieve him, is there enough evidence to support the proposition that the defendant was thinking about this murder and planning it out and premeditating it out 2 to 4 weeks before it happened? Of course there is. Of course there is. What Kenneth Barron said fits in with all of the other facts and all the other evidence that was gleaned in the state's case, right? Is there any reason to disbelieve Kenneth Barron? All of this evidence, all of it shows that the state has been able to establish this particular aggravator beyond a reasonable doubt. And then the final sub-element is this. It was carried out without any pretense of moral or legal justification, and then it defines that as any claim of justification or excuse, though insufficient to reduce the degree of murder, rebuts the cold, calculated, premeditated nature of the murder. Okay, so have you been presented with any evidence that would either justify or excuse these homicides? No. No. There's no question that we have proven this aggravator beyond a reasonable doubt. And so remember, then we get to the mitigating evidence, right? Then we get to the mitigating evidence. And let's take a fair look at it and figure out where to go from here. And remember, as we all discussed in jury selection, we consider everything, right? Everything we consider. But then after we consider it, what do? We figure out how much weight it deserves, right? So that's what the law says. The most impactful mitigator certainly is the fact that this defendant has no significant criminal history. You obviously consider that and obviously give it whatever weight that you believe it deserves. It's up to you to decide how much value this mitigator has after you weigh it against the aggravators, right? So it's weighed against it. The first, I think it was the first witness that was presented yesterday was Raul Bonasco. He was the fellow who testified via Zoom. He's your prison expert, and he worked with the Department of Corrections. I think he's in Texas now.
Mr. Evans left his book at the podium there.
If I understood him correctly, the gist of his testimony was, well, okay, we get it. The defendant will adjust well to prison life, and he's going to be able to follow all the rules and not become a problem. So that's what you're being asked to believe, okay? Well, let's think about that. Let's consider that for a second. If I understood Bonasco's testimony correctly, he met with the defendant for an hour and a half, right? He talked to the defendant, someone who is facing the death penalty, and he talked to him for an hour and a half. He then reviewed the defendant's behavioral records from St. Lucie County Jail, right? And based on that, he arrives at the conclusion that he will not be a problem in prison. Okay. Even if he were to be able to accurately predict that, and there's no guarantee that he can. After all, he's going to go to prison, right? If there is ever an unpredictable environment in this world, it would be prison, right? You're not talking about a bunch of rule followers in prison. They're there for a reason.
Am I right or am I right?
So let's assume
this is like a Groundhog Day.
Let's just, for argument's sake, let's be fair. For argument's sake, let's assume that he can accurately predict that.
Ooh, Hollyland
right?
transmitter.
Let's assume that he's accurate in that. How much weight do you give that? right? How much weight would you honestly assign that when you're looking at the aggravating evidence in this case? How much weight would that be? Would that honestly give and fairly give when you view this evidence objectively? When you view it objectively, how much weight would you give that? The answer is very little, very little. So then we get to Lucinda Cook. Lucinda Cook is the ex-girlfriend. She says that she was in a relationship with him between 2006 and 2012. She didn't have a meaningful conversation with this defendant for 13 years. Right? That was her testimony. She has not spoken to him in a meaningful way for 13 years. Until just a few weeks ago. I think her testimony was a month ago I spoke to him. So either during the jury selection process or right before the jury selection process, the defendant re-enters her life. Right? The defendant re-enters her life. Okay. Again, and she also said, well, he was never violent with me. Okay. He was never violent with her. Okay. So again, the question is, and only you can answer this, is how much weight would you assign that? Right? How much weight would you honestly assign that? Somebody who hasn't spoken to him in 13 years, how much weight do we give that evidence? Very low. Very low. And then, of course, today you have the defendant's mother and his other family members. Okay, again, highly emotional testimony, as you would expect, right? And of course, they're going to have good things to say about him, as you would expect, right? No surprise, as you would expect. His mother is going to come in and say nice things about her son in these horrific, horrific circumstances. So, again, my question would be, how much weight would you give that? Right? I mean, if we're here to give our reasoned judgment and weigh the facts and the evidence out and apply it to the law in as dispassionate a way as we possibly can. Right? We're not here to be swayed by our emotions. Emotional people make bad decisions. If we weigh this out as dispassionately as we possibly can, would we give this testimony any weight? I think you give it minimal weight. At best, you give it minimal weight. And of course, we finally arrive at the weighing process, right? And again, this is directly from the jury instructions that we spoke about at length during jury selection. And it's very, very straightforward, very, very simple. You know, whether sufficient aggravating factors exist, which of course they do, and then whether the proven aggravating factors outweigh the proven mitigating factors. That's it. That's all you do. So, I end with this. You know, our criminal justice system relies on accountability. Right? Our criminal justice system demands accountability. And part of that is to punish people proportionate to the crimes that they've committed. Punish them proportionate to the crimes that they have committed. This defendant, he murdered Tanya and Josiah Wise for no other reason than he believed that he would lose everything if his wife found out about the pregnancy. He could have come clean to his wife. He could have paid child support. He could have been accountable to his wife. But he didn't do that. He planned this murder out for a lengthy period of time. And he executed that plan. That's what he did. That's what you found. Extreme facts call for an extreme sentences. That's what we're here for today. Ladies and gentlemen, this defendant deserves not one, but 2 death sentences. Extreme facts call for extreme sentence. That's what I'm asking you to impose today. I'm asking you to impose a unanimous vote on both counts for the death sentence in each count. On behalf of Tom Backethoff, your state attorney, on behalf of the people of the state of Florida, I thank you for your patience and your service this month.
Throws his boss's name in there real quick.
It is, I speak for everybody. It is truly appreciated on everybody's part. Thank you so much. Thank you.
Now defense gets to go. This is the last word. There will be no rebuttal.
Yes, thank you, Your Honor. Thank you.
I imagine this will be emotional. This is almost all they have.
Tanya Wise. Josiah Wise, murdered by Jose, who is my client. The trial is always about the accused, but the case is about those two. The main facts of the case are that they are not here anymore. And I tell you that because it's true. And I tell you that because I wish you to recognize that I know it. None of the evidence that has come before you has been received by me in any inhuman or different way than you have received it. I've just lived with it for a much longer time.
What is he doing?
I wish to respond to some of the things that Prosecutor Richardson just indicated. He made a very strong case, and I told you yesterday that I am not going to quarrel with the fact that this was a coldly and calculatedly and premeditatedly done act.
Premeditatedly.
We have Jose's voice in his truck a couple of days before this. That was his plan. I don't dispute that. So what does that mean for you?
You said his wife did it.
Well, it means you're going to unanimously find that there is an aggravator. And the gate is swinging wide open for you to kill him if you want to now. Last legal requirement is met. The baby. I told you yesterday that those photos look to me much like a newborn baby. Certainly less than 12 years of age. I don't argue that aggravator. Now there are 2. I'm here to try to save my guy's life, not insult your intelligence. Those 2 factors are there. I don't have arguments against them that are in any way meaningful. That the crimes were committed while there were contemporaneous other capital felonies going on. Jose kills Tanya, the baby, is a contemporaneous crime. They work back and forth as aggravators. If you wish to find them so unanimously, I will only say this. The existence of the baby Josiah, the fact that Tanya was pregnant, is clearly a central fact. But Jose's intent, while it would necessarily have to cover the baby, his anger, his hatred, whatever it was that was really pushing him and motivating him along, was aimed at Tanya. There were no abdominal injuries. No indication of hatred toward the baby. Mr. Richardson tells you that because Jose said I'd lose everything, that therefore, beyond a reasonable doubt, you should all conclude that this crime was done for or affected by financial gain. No, that is not proved. If you are worrying about losing your marriage, that doesn't mean you're worried because there might be financial implications. If you're worried about losing your job because your wife is a supervisor, the uncontroverted evidence before you is that Jose has worked steadily since he's 15 and been totally self-sufficient. A divorce is not going to knock him off kilter. Fearing having to look for a new job is not going to prompt him to do a murder. That this crime was done for financial gain is not proved beyond a reasonable doubt. because of the consequences of divorce, because of child support. He paid child support for 3 children, is the evidence before you, and gave groceries and clothing for the 4th. That is not proved. Extreme facts require, says the state, an extreme sentence. These are horrible facts. Every murder is comprised of horrible facts and would consist of photos of a victim in sight, photos of a victim during autopsy. Jose, according to the evidence, planned to get Tanya to a place and kill her. That's every mob hit ever. Let's get Paulie to the club and we'll whack him. That's not an extreme fact. That's an ordinary fact. We're talking about facts of murder, mind you.
Not for us.
We're talking about murder. To get someone to a place where no one can see to do the crime is not extreme. It's common. In murder.
But murder is not common.
Raul Benasco spent 90 minutes with Jose. Perhaps Mr. Richardson would prefer that he moved in with him for a year in his cell. How long is a man supposed to sit with them to learn some history and review his prison record, which is what the man's expertise is all about? That Lucinda Cook had no communication with Jose for 13 years and yet came in here after all that time to speak on his behalf doesn't count against him, it counts for him. What kind of an impression did he make on her? That after all this time she consults, she prays, and she comes in. When other people are jumping ship, she comes in. And her intention is not to tell you who he is now or quarrel with you about your verdict. It's to say, look, whatever you found that he did, I'm surprised by it because that's not the way he behaved with me and with my children. With us, he made us feel safe. And that takes me to kind of one of the topics that I want to discuss with you. I had hoped to just roll through here without having to refer to anything written, but the situation changed with my witnesses and whatnot, and so I'm going to refer to some topics here, and then I'm going to explain them to you.
It was my plan to not be prepared.
One of the things that's going on here, I'm going to refer to as box and balloon. Box and balloon, it sounds like a kid's game. Bear with me here. The box is the life of Jose Soto-Escalera. In toto, everything. From birth to now, certainly from birth to the time he did the murder. And as you heard from his family, yeah, it's what's expected from family. Would your family come in and run you under the bus? I hope not. So, he was good. He was generous. He was uplifting. He was a mediator. He left and encouraged us to come out. There were good things to Jose. He comes to Florida. There are women who say good things about him. Madeline Colon and Lucinda Cook. He has long-term relationships with them. He supports emotionally and otherwise children that are his and that aren't his. He brings safety to women who are recovering from traumatic relationships. All that is in the box. At the bottom, we insert a balloon. The balloon is this crime. It is this murder.
That gesture.
It inflates because it is the chief act within all the acts of that box. The question for you is, how big does the balloon get? Does it crowd out every other thing in a man's existence to the point where you regard him as almost inhuman and therefore like a cigarette butt or a cockroach?
His foot on the floor.
He's not. He's a horrible, horrible killer. And other things too. One of the topics I have written down here is humility. Humility. I recommend humility to myself. I don't always follow. I recommend humility to most people in most circumstances, and I most absolutely recommend it to you here in thinking about this.
You be humble.
Why do I say this? Because you made an impression on me. When I sat back while Ms. Minton did all the work early in the case, I was watching and I was listening and I was very impressed with your confidence. How confidently you all said, this one I'd kill him, I'd kill him, I'd kill him, this one, I don't know. You're very confident in your ability to make these judgments. And I wonder, in addition to being impressed, I say, how do these people come by this confidence? Do you have education? Do you have experience in this regard? You were on the streets a couple of weeks ago, now you're in here deciding who lives and who dies. That's correct according to the law. And it's probably good that we don't leave it up to just one person. But I still think you ought to think about how perfectly suited you are to do this. Take a look.
Whoa.
Think.
Let he who is without sin cast the first stone is what he's trying to get at there.
How many of you thought about how you think? Probably not. It's a thing you do. You put on your shoes, you make a bowl of cereal, you think. You're thinking all day. Your mind's taking you here and there. How exactly does it work? When have you examined the functioning of your brain? Look to that door right there. Let's use our imaginations. These folks here are essentially asking you to put a target on Jose's back and make arrangements for death to do his thing with this guy, because the law permits you to do it and you would decide that's what should be done. So through that door now comes death. Death is coming in. Coming through the gate. Death is right here. I'm asking you to imagine if death is right here in the room with us. How many of you perceive death right here in the room with us as a female? None of you, right? As a child, none of you, right? It was some hulking, some version of the Grim Reaper, right?
Little baby death.
You have conclusions and ways and things in your brain and you don't even know how they got in there. Death could be a woman. Death could be a child. It could be a noxious cloud. But you, I'm pretty sure, had death as a male. In what other ways do you think or make decisions and you're not even exactly sure why? This is intended to be an abiding decision. Live with you forever. Like your religion, like you love your children, like your sports team, things you don't change. And so if you decide to kill Jose, that means that you are right now, today, knowing how you're going to think forever, right now you're going to lock your brain into an unyielding rigidity that says, kill him. And if someone asks you next year, or in 10 years, or in 20 years, oh yeah, I'm still good with it. That's what it means. And that's why I say you should approach this with some humility.
I don't think you know what the word means.
I want you to imagine something else. I'm going to call it a...
Oh, here we go.
Spectrum of death. Jose is on it. Over here is one end. And I'm at this end, and you're at this end, and everyone else in this room is at this end because we had no involvement with killing. Never killed anyone? Never thought about it? And certainly didn't engineer it and make a heavy-duty recommendation that it be done. We are all over here, unstained and unsullied by any association with death and killing. Jose is on the spectrum here. Jose is on the spectrum. Let's make this mark on the spectrum where we started with Ashley Minton's questions to you.
Jose is on the spectrum.
Over, we've got a murderer, a first-degree murderer who intended to do it. Now, we have a little more than that. We have some aggravators. So Jose's a little further on the spectrum of death. Way out here at the other end of the spectrum of death is we'll put our state actors. Your Hitlers, your Stalins, people who killed in the millions. It's not really relevant to us, but it's out there because what you need to comprehend, and I don't know if it's ever come through in all the system, in all the sessions that we had, how do we decide what is a death penalty case? The people that you send to Tallahassee, when they become geniuses and philosopher kings, they look at the spectrum of murder, all of it, and say, okay, where are we going to pin it to say what is a death penalty case?
Well, we went over that just a minute ago. It seemed pretty clear.
And so, the whole circumstance that we found ourselves in, since the first group came in here on September 2nd, is we are wallowing around in death and talking about death, and the first thing we do before we have a trial is talk about the death penalty. And you're a jury of Jose's peers. But as you know from your individual groups, a lot of your peers didn't like the death penalty, but they're on the outside of the door now. So what I'm looking at is a box full of
killers. What?
I won't say killers, but people who are comfortable with it.
Whoa!
You all said many, many times, "Oh yeah." Up and down the road, said, "Will you go death? I'll do. Yep. Yes. You're the same people who just convicted him.
You say they're just as bad as he is.
And I'm just one guy with some words, and I'm afraid you kind of roll right through me and try and kill him, but you don't have to. Here's one simple thing. And in thinking about this argument and then making it, I kept coming back to it because I'm a very simple person, possibly a simpleton.
Simpleton.
And it is this: why would any ordinary, decent person with a conscience orchestrate a death if they don't have to? Why would you make someone die if it's not required? And it is not required under any circumstances that you have heard or will hear. If Jose is to die judicially, it's because you did it. You want it to be done.
Wow.
The judge can't do it on his own. You have to do it. And so you, I'll use the word contort, but maybe your brains flip right into that position naturally. I would say you have to contort yourself and everything you believe and your consciences to get to a place where you can say, I'm morally comfortable with killing a guy.
This is so inappropriate.
Let me talk about some of the mitigators. Where's my list of mitigators? There are a lot of mitigators.
I have not seen a stream of consciousness like this since Judge Schroeder.
Because anything can be a mitigator. And I'm behind the 8 ball. So I'm going to throw a lot of mitigators out there. I don't suggest they're all of equal weight. I don't even consider them all of equal weight. But I don't know which one you back there might latch on to. So I'm going to run through them quick. I might highlight a couple of them. This list will be attached to the instructions. It will be part of the instructions that the judge will read you, so you don't have to remember it. There are 29 of them, and some of them strike the same theme, but if Jose was nice to 4 people, I'm going to name them all individually. As you have heard, as the judge has told you, there's no the dispute that Jose has no significant history of prior criminality. That I will highlight for a moment, because that is an extraordinary fact. Do you recognize that? This is a convicted double murderer who did nothing prior.
You don't know that.
And I think that's important, and I suggest you should think that's important, because if I'm going to make a heavy recommendation that a judge kill someone, it should be a bad person. It should be a very bad person. It should be a pretty bad person through and through. That's not who Jose is. This is an explosion of violence that comes out of nowhere in his life. It doesn't make it any better. Still makes it a murder. But it doesn't make him the type of utterly useless human who you might want to put down. He's not utterly useless. And this is not in keeping with anything that he has exhibited before. And that is very important. Jose was abandoned by his father as a child, raised in chronic poverty. I'm going to stop on that one for a minute because we did discuss that many times and a lot of people in jury selection didn't like it. And remember, we're past the guilt phase. No one is saying, poor Jose, you let him go because he grew up in poverty. But poverty brings challenges. That's all I ask you to recognize. You know, we
thank you, Sandy Graham.
We acknowledge the importance of 2-parent homes and sufficient money to meet our needs, and yet if people don't have that, we really don't cut them any slack about it. All I'm saying is consider it as a mitigating factor. He had less than probably you and many others. I don't know exactly what that means. My dad was a school teacher. Jose suffers from transgenerational family trauma. There's problems with the mama, problems with him, problems growing up in Bridgeport with no money. Chronic exposure to trauma during his childhood. The mama seems to remember the house being fine and the neighborhood fine, but it was not fine. You heard from the cousins. This is not a fine neighborhood. It was a violent neighborhood where drugs were dealt on the streets and crime was in the streets and crime was seen. And that's not an ordinary way to grow up. Jose can positively contribute to society in prison as a worker. I don't contend that that is an especially weighty concern, but it is a totally relevant concern because remember, where is it? It's life without parole. Look at that. It's like a forgotten option somewhere. Well, I blow the dust off at night and it looks pretty good. It looks fine to me. Life without parole. Let's remember, and I will recall to you what you told us also at the same time, within probably 2 seconds of telling us you all can impose the death penalty, you all said you would consider life without possibility of parole. And if you're sitting here now not doing it, you're not following the law and you're not doing your job. If you decided last week he's guilty and you're going to kill him, you're working a charade and a fraud on us right now. So everybody's mind better be open. You don't have to like what I'm telling you, but you got to listen to it. And you told us you would consider it. And I'm not exactly striking the tone of a beggar here, but nevertheless, you have a job to do and I'm going to make sure that you do it.
He's not winning the
Jose
jury
has
over.
established and maintains long-term substantive meaningful relationships with friends. Jose has established close family bonds and relationships with his cousins. You know penalties have consequences that ripple. You're going to kill someone. You know that. You heard from the victims in the case.
I'm worried about the lectern there. It's going to be knocked over.
Jose has maintained a close relationship with his mother, maintains close family bonds with his children. You know, that's supposed to be the motive here. And yet he said opportunity galore and never killed anyone. That doesn't mean he didn't do this, he did. But if he is monstrously wrong for killing one child, you can't deny him or deny the existence of the fact that he helped and contributed and lived a meaningful part of his other children's lives for a long time.
What are you saying? 4 out of 5 isn't bad?
I don't know if there's a rug back in the jury room, but you would not be doing right to pick up the corner of it and sweep facts you don't like under it. Jose demonstrated exemplary jail behavior. He poses no danger to prison staff or inmates. Again, these are all relevant considerations if he is going to be living for years before execution and living out the rest of his life in prison. How he will do in prison is completely relevant for you to consider. Jose has been a positive influence on family members. Jose will be required to work 60 hours a week. That's every day in DOC.
60 hours a week he's required to work?
As a prisoner, you know...
Did he just laugh?
Jose's a prisoner. He's been a prisoner for 7 years. When you capture prisoners in war, you don't kill them. It's a war crime. But here, it's okay to kill prisoners. Think about that. You're being asked to kill a prisoner. He's neutered. He's nothing.
He's not neutered.
He's been in handcuffs and shackles behind bars in a secure jail, guarded 24/7 for more than 7 years. What is the need to kill him? You got that much of an urge? Take him out of his cage and put him down?
Whoa.
He's helpless. He's hopeless.
Why don't they object?
That's enough. Your common sense should tell you your understanding of the world, at least the United States, should tell you that there's plenty of states that don't have a death penalty at all.
Go commit murders there then. But you chose
and they might
Florida.
say, well, he's a prisoner. You got killed. You kill prisoners. That's where your morality is. You kill prisoners.
Look at prosecution.
Prisoner. Jose was a positive influence on his former girlfriends and their children. Jose can be redeemed. For that matter, you know what Jose did 7 years ago. Do you know where his head is at now? If he's taken out in several years and executed, you kill the body, but what is his head? Where will his mind be at, do you know? Will he be the same person? Because that's how punishment works. Of course, who among us hasn't suddenly snatched up one of our children, put him over our knee, administered a spanking, and said, that's for what you did 7 months ago. It's not how punishment should work. Jose provides support for his children. No prior history of violence. No criminality, no violence. He has helped his former girlfriend and his son's mother escape dangerous domestic violence situations. He has always been a hard worker in manual labor fields, furniture delivery, security work, others. Jose escaped a high-crime, high-poverty area independently, moving to Florida when he was just 15 years old, and he made it on his own. Despite lacking the opportunity to complete his education, he overcame that lack of education through consistent work ethic. He never took a dime of public money, even though he was just a teenager. And again, that undercuts the argument that he did this killing in any way connected to or for or about pecuniary or financial gain. He's always had to work and always had money.
Prosecutor checks his watch.
Jose has exhibited excellent courtroom behavior. You probably know that people accused of crimes, especially murderers, especially in long trials and processes, they don't always keep their mouths shut and they don't always behave. Jose has behaved just as he's behaved as an inmate. Jose will continue to offer positive life influence on his children, family members, and friends who have become emotionally dependent on him. He began working and earning money to help support his family at a young age. He's always been self-supporting, as I mentioned, not a drain on society. Some, if not all of those, you should find exist a little more likely than not, and then you are required to consider them. What weight you give them is completely up to you. This part of the process seemed to confuse a lot of your fellow people who didn't make it onto the jury, who kept insisting that the law, they're just going to follow the law. The law is depositing you off here at a crossroads if you don't realize it yet. Okay, you are going to tell the law what will happen here. Life, forever and ever, until you die and they take you out of prison, or death penalty. And the law doesn't tell you which one, but the law does tell you that life without possibility of parole, like the stepchild option in here, is not a stepchild option. It's perfectly good. The law gives you a choice because it's perfectly happy with the life. Perfectly happy. And so should you be. It would keep you off the spectrum of death. If you do order and recommend that Jose be killed, you're not outside over here off the spectrum of death. You move a little bit closer to him. You now have some involvement in killing. Not that you'll do it yourself. You'll just...
This is so wrong.
Set the first domino falling that will result in it.
You have blood on your hands. How will you sleep at night? How can you look yourself in the mirror? How can you look at your kids in the future if you do this? This is the
Jurors
wrong
isolated. from the execution. You're making a moral decision, but you're not making it in a vacuum, and don't think because it will happen years down the line and you won't be there and the needle won't be in your hand that you're not responsible. That's my point to you. You are responsible.
Object.
The prison's far away. You're still responsible if it happens. Well, someone else in the state's employ, the state executioner, will do it, so your hands will be dirty, but it's your handiwork that will be done. So don't think of it as just, you making a death recommendation is like dropping some instructions off on your secretary's desk as you leave for a long weekend. It is not that. Victim impact statements. We heard from several members of Tanya's family. Her mother, I suggest, especially, and her son, who I thought testified very impressively for his mother. And it may not matter coming from me, but I'm quite certain his mother is proud of him and would be proud of him. But I hate victim impact statements, not for the reason you probably think. Because, in fact, I love victim impact statements done right. Victims should have a voice. They should be heard, especially in crimes of violence and especially in loss of life cases. I think victim impact statements should be published in the newspaper, and court administration should pay for it. They should have a voice. But here, in this process, that voice is best expressed to the judge with experience, not to the jurors with none. Because within this tight process that you're following that might lead to someone's death, in comes these victim impact statements, and where do they fit into the process? They do not. What will the judge tell you? Well, the purpose is to establish the uniqueness of the victim and the impact on the family and community. Who would dispute that a murder victim is unique? Everyone in here. We're all the same and all exactly different. Of course, Tanya Wise is unique and special and has special characteristics and qualities.
That tone, speaking about the murder
victim, but the only thing that you're instructed to do is not regard it as an aggravator. Well, what are you hearing for then? It for sure ain't no mitigator. Every single one of those statements is like an emotion bomb, a sympathy grenade going off, bespattering the walls with sympathy. Not from my guy. In fact, it is so much seeming like an aggravator that you have to be told it's not an aggravator. So that's one thing I don't like about it, that it's dropped in here unfairly. It operates against me and my client, but what am I supposed to do with it? What are you supposed to do with it? It's not an aggravator, and you're only supposed to be deciding the case on aggravators and mitigators, so what are you supposed to do with it? And the other reason I don't like it is because it lends itself to being a victim ranking system. If Tanya Wise had no family whatsoever to come in here for her and give victim impact statements, is her life and her murder any less important thereby? No. If Tanya Wise was the chief of surgery at the local hospital and saved hundreds of lives through her surgical skills, would that make a difference? It should not. One man, one vote, one murder victim, all the same. They're all the same. Every life is valued the same. No life is valued more than another. If Tanya had nobody to come, if that whole segment was not here at all, okay, it's victim impact time. No one stay here. So what are you supposed to do? She must not be worth very much. Right? Or, look, if there's 100 people coming, she must be worth so much. It's a victim ranking system. It stinks. Everyone's the same. No one deserves to be killed, no matter who you are. And so I don't like it for that reason. Look, this case is loaded with emotion from top to bottom. And that's just a gigantic injection of it, and For what? I'm not sure what you're supposed to do with it, and you can't be sure either because it doesn't fit in. It's not an aggravator or a mitigator. That's what we're doing here. We're weighing aggravators and mitigators. We're figuring out factors of his character that might lead you to not kill him. That Tanya is unique. That her family is mourning. That there's a void that won't be filled. Yes. But that's not the point. The point is that she is a person who should be alive and is not now, due to Jose's criminality. Who she is important, but it's important outside of this process. Here's another one of my little topics that I wrote. This is not a fixable situation. You know that. I'm just gone for 7 years now, which is why I never had a chance. Never began. Whether he is imprisoned, Jose, for the rest of his life, or whether he gets taken out at some point and injected to death, whatever they put in there, Tanya and Josiah will not come back. It can't be made right. And we, you, me, that doesn't, it just doesn't fit right. And I think it especially doesn't fit right for Americans because we don't think, okay, what are we going to do about it? Let's do something. There's nothing meaningful that can be done. If there are people rooting for the death of Jose, I don't know that there are. If that day comes, they may experience a moment or a day of satisfaction, but I think the next day after, the heaviness and the sadness of the loss is still there. It's undiminished. That's the fact. He lives or dies is less important than the loss that cannot be made right. Killing him won't fix it. It won't fix it. It won't take the pain away. Well, let's talk about something that we mentioned in jury selection. Which, by the way, does it seem that Ms. Minton, that poor Ashley did so much of the work here in this case and I did relatively so little? That's my fault. Here's a little inside baseball for you. This is my case. I am lead attorney in the case, and Ms. Minton works for me, so to speak, under my supervision.
And I did nothing. You made her do all the work.
And I could have done everything, or I could have done nothing. But like I told you yesterday, I waited a long time for my chance to speak to you. And the detectives among you have already figured out, because I knew I would be here. I knew there would be a penalty phase.
You knew?
And I figured that this would be the
I knew there would be a penalty
part
phase?
Of the trial for Mr. Jose Soto-Escalera. And so I figured that this ought to be my post of duty and not Miss Ashley's post of duty. But everything that has transpired in this courtroom has been done with my knowledge and my approval from the defense side of things. And you know what? You know why? Maybe you're thinking, well, hey, Attorney Burns, what did you drag us to a trial for if you figured your guy was guilty already? Because they're trying to kill my guy, and they're going to cross every T and dot every I before they get to do that. Late in a losing game, a losing effort, the final seconds click off the clock. The quarterback doesn't drop back in the pocket and take a knee and give up.
He's throwing a Hail Mary.
He keeps the ball as far as he can and hopes for a miracle. Do you think you are the only ones who can read and understand and appreciate and see evidence and what it means? I've been doing this for a long time. Whatever you can do in that regard, I can do better. I knew I would be here.
He is insulting them blatantly
and
to their
make
face.
No apologies for fighting every step of the way, including now. And frankly, I feel like I'm in the last ditch. maybe fighting you all off when I got nothing but a rusty sword in my hand, a slingshot, nothing but words. And I really don't want you to kill my guy. But we're going to talk now about mercy. I hear some of your voices. I hear them from here saying, oh, counselor. Attorney Burns, I was kind of half with you, sort of paying attention up to this point. But mercy for this guy? Mercy. You may, if you hearken back just a few weeks, you will recall when Miss Ashley was addressing this topic with you. The point that was attempted to be made and the distinction to be made is how does mercy work? Does the guy who gets it have to earn it? The people who give it just give it? The concept, I believe, that was attempted to be taught to you, and there's not really much time in that classroom where you have to address 20 other matters, is that mercy is always in the power of the victor. Weak people, losers, don't get to grant mercy. People who have power get to grant mercy. And so, whether it's withheld or granted has very little to do with the recipient and very much to do with you, the grantors. It's a statement of who you are.
This is wild.
And so, if any of you are still even within earshot on this issue of mercy,
he knows he's lost.
You need to just consult yourself and say, look, am I a merciful person or not? What does mercy mean in this case? The merciful thing is to condemn Jose to live for decades and decades and decades in prison behind bars until he dies. To become institutionalized and infantilized over time and told when to go to bed and when lights on and lights out and when to eat and not to eat and look through bars and never get out. If I imprison you guys in your old high schools, how long would it be before you went crazy?
Are you threatening? Is that...
He'll be in a prison. That's... Most people would not consider that a merciful result, but that's what mercy means here. So it's not a great big fat dollop of mercy, go forth, Jose. It's a little drop of mercy that says, I'm going to kill you. That's all the mercy that would be requested here. Let me take you back a couple of days, and I'm going to read you some words that Judge Merman read to you in describing the elements of first-degree murder. And then I'm going to make an argument from that by reworking those words a little bit. None of what I say to you is a legal instruction. It's just an argument. It's just food for thought. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing.
He's accusing the jurors.
The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. That's what the judge read to you. Now I'm going to change it up a little bit.
This is bad. This
killing
is so
with premeditation is killing after consciously deciding to do so. The decision must be present in the mind of each juror at the time of engineering the killing.
Object.
The law does not fix the exact period of time that must pass between proper argument.
Finally! Holy smokes. This whole defense argument from start to finish has been improper. It has been improper from the very beginning to the end. And for the state to sit there through all of this How many times did the defense attorney equate the jury to the defendant in their actions? If you vote to kill him, how would you be any better than my guy? And now he's reading the law to them, saying, look, you're committing murder. You're doing it right here, together as a group. He's insulted them on every single front. I can do your job better than you can. I know more. Now, I can understand, and I respect the fact that there are some people out there who are just on a principle basis against the death penalty, and that is great. I encourage that debate. It's wonderful. I say take it, go political with it. Change the law if that's your mind. But the law here has the death penalty, and part of the punishment that's affixed to a sentence like this is that the punishment serves to keep other people from doing the same thing. It's not just to keep him from killing again, right? There's going to be no recidivism. He's going to be locked up forever, okay? He's never getting out. It's not going to be like, well, he's back and he did another one, right? That won't happen. And if we kill him or lock him up life patrol, it doesn't change that. But the law builds these punishments in so that other people can observe the punishments that criminals get and say, I don't want to be that guy. And how do we know it works? Well, the fact that you're fighting against it, saying, don't kill my guy, clearly it's something he doesn't want. And if that's forced on somebody because their actions are so heinous that society rejects them and says, you can no longer breathe the same air as us, be done, maybe that will have an impact on somebody. That's the argument. Now, I'm not saying it's right or wrong, but what the defense is arguing here is wrong. To argue we need some soft, soothing music. To insult the jury like this, to insult the legal system like he has, that's fine. You've told us you were against the death penalty. That's great. I understand that. Make that argument. Tell him, look, it's going to cost more to kill him than to keep him alive. Tell him. It's the truth. I admit that 100%. What is it in Florida? $24 million? It'll cost $24 million to execute Jose. It'll cost a lot less than that just to keep him in a 12x5. For who knows how many years. As many years, 100 years, it would be cheaper. It's argument against the victim impact statements. If there was ever a case where the victim impact statements were perfectly in line with the purpose and scope that the law allowed, this would be the one. They never mentioned Jose once in any of their comments. They gave a voice to the victim who has no voice other than that because your client ended it.
You may continue.
Right. What I'm saying to you is the process that you are relying on should be pretty ironclad. It should be clear. You should be able, if you're going to decide as jurors to impose the death penalty, to plant your foot on one firm piece of ground after another all the way through to that decision. And if there's something strange that comes into that process, you should consider it. You should weigh that. Because as Ms. Minton told you in jury selection, this is a moral decision that you make as individuals. And it should be based on a system that you understand and that you can follow. I am going to talk about what you've been asked to do last week and what you're asked to do now. And I'm going to do a compare and contrast. At no point am I suggesting that anything you do or might do is illegal. I am not asking that anything you do or not do is in any way related to you being murderers or illegal killers.
That's exactly what
or
you're
equating you in any moral way with Jose. But you were asked last week to convict a man because he thought about doing a killing beforehand and did it. What are you being asked to do?
Without color of law.
Objection, again, improper argument. The difference is...
I'll complete the thought and I'll rule on the objection if there is one.
The process that is before you, if you follow the instructions and carry it out and think about it, means that you're thinking about forming the intention to ask the judge, recommend the judge to kill Jose. So in this circumstance, it's righteous, right?
With legal authority.
So sometimes thinking real hard about doing a killing is okay. If you're comfortable with that.
My guy thought for a long time. See, he's the same as you.
If you should go back there and 8 or more of you decide independently, and by the way, this is an independent thing. I don't say you can't talk to one another or nothing like that. But so far you have kind of walked the path together. Jury selection, you get on the jury, you hear the evidence, you've made your decision, and now all of you stand here at the point together. But you sort of come up the stem with a base of a Y, and now you're at the V part and you're looking at the crossroads. That's where the law has deposited you now. And I have acknowledged that the state has demonstrated that there are aggravators. And as I told you, the gate is open for you to kill. And I recommended humility. I recommend you don't go down that path. I wonder, with that gate open, I don't actually think so, looking at you, but if any of you might now, or in 5 minutes or 10 minutes, regard it as some sort of a temptation. No one gets to be in your position, very few people, to say, live or die. Look at here he is.
What?
Live or die, it's up to you.
Now's my chance. I can finally kill someone on a jury.
Walk the path that people don't get to walk. It's a forbidden path, highly forbidden. But it's open to you. If you should find it alluring or tempting in any way, the forbidden fruit of control over someone's life or death, you're not in the Garden of Eden being tempted, you're in the Valley of Death being tempted. Walk out of it. Go away. Take the other path. Do not do any killing that is not absolutely required, and this is not required ever. Sometimes
You did say Garden of Eden.
large matters can be understood in simple ways and things that might happen all of a sudden. And you don't even know it until it happens. And one of those, I'm going to hang with me here if you can on this example, is I call it lean in, lean out. Lean in, lean out.
Oh, good.
People
Here we go.
lean in, they like something. Lean out when they don't.
Shake it all about. That's what it's all about.
Lean in to give that first kiss. Hopefully someone's leaning back. Maybe they're not. Maybe they get to lean back. Never happened to me, of course. But
what? I've never had anyone lean back when I tried to kiss them.
in this way, if you are a juror who votes to oppose the death penalty, and you should remember this is an abiding decision. You're good with it now, you're good with it tomorrow, you're good with it forever. You should end up in conversation with someone, the topic comes up. And what did you do? I voted to kill him. Whoa. You're going to get the whoa.
This is
You're not
wrong.
going to get the quiet. And the person hasn't even had a chance to think about it. It hasn't penetrate to the consciousness of that hearer at all, but you're going to get this, you're going to draw back in a well because you just admitted to them that you're on the spectrum. You're on the killing spectrum.
Your family and friends
the rest
will
of us have
disown
nothing
you.
to do with it. You just said, yeah, I set a man up to die. And that doesn't get on. I guess so. Think about that.
This is wrong. And it's wrong of the judge to let it go on.
This is a big decision. Yeah, I'm just about done. I'm running out of juice. When you go home this afternoon, after having come back and given us your decision, you will now be a life giver or a life taker. You're not going to be the same. If you vote to set the wheels in motion, to give a heavy recommendation to this judge to kill this man, you're not going to be the same. This is a life taker. You are not.
Don't be a Jose. That's your line. Don't be a Jose.
Leave the life taker alone on the spectrum of death. Don't take a step nearer to him. You don't have to. I invite you in my final words to consult your best selves, the highest portions of your consciences, the lightness in your heart, not the darkness in your heart. To rot and die in prison is not merciful. It is a horrible, horrible sentence. Do that to him. Thank you.
Thank you, attorneys. Members of the jury, I'm about to instruct you before you deliberate.
Don't be a Mr. Burns
The
either.
instructions, just as in the guilt phase, are in writing, and a copy for each of you. We'll go back into the jury room during deliberations for your further reference should you need it. However, do pay close attention to the instructions I'm about to give you. And for those of you who are in the audience, the instructions will only take about 10 minutes. You must stay for the entire instructions so as to not distract the jury as they pay close attention to these instructions. Members of the jury, you have heard all the evidence and argument of counsel. Now you must decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state applicable to each victim are: 1, the defendant was previously or contemporaneously convicted of another capital felony. The crimes of first-degree murder and first-degree murder of an unborn child are capital felonies. 2, the first-degree murder was committed for financial gain. And 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The term cold means the murder was the product of calm and cool reflection. The term calculated means having a careful plan or pre-arranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. The aggravating factor alleged by the state that applies only to the unborn child is the victim of the first-degree murder was a person less than 12 years of age. You have heard evidence about the impact of this murder on the family, friends, or community of Tanya Wise and her unborn child. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Tanya Wise's death and that of her unborn child. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each alleged aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find each aggravating factor has been proven beyond a reasonable doubt. And the verdict form itself is in conformity with that. As to each of the counts, there's a section for you to do just that, and it will be self-explanatory when you see it. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances need not be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: 1. Jose Soto-Escalera has no significant history of prior criminal activity, and 2. The existence of any other factors in Jose Soto-Escalera's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. A list is attached hereto to these instructions for your convenience regarding the defendant's proposed mitigating circumstances alluded to by his attorney. That is, the list is behind your instructions as Mr. Burns argued them. The final step in the process is for the jury to determine whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all of the following factors. 1. Whether sufficient aggravating factors exist. And 2. Whether the proven aggravating factor or factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty, the court must sentence the defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation is for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight and deference to your recommendation. You will be provided a form to reflect your decisions, which is a verdict form. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake and bring your best judgment to bear in reaching your decisions. That concludes the instructions, and at this time, the jury, with the exception of our 4 alternates who now at this stage know who they are, that Ms. Emmert.
Good work there. Thanks, Court TV, for doing that.
Here, the remainder may proceed to the jury room, and if the alternates have items in the jury room, the ballots will retrieve them. The jury should proceed to the jury room to consider its verdict.
Okay, I have additional thoughts. As soon as I close the door, we're going to start the timer, which needs to be down here.
All right, the jury has exited at this time. Ladies, this actually does conclude completely your service in the case. I want to reiterate what I told you, whenever that was. When was that? Last week, some point, that you know what the purpose was for you in this case. If someone had fell ill or had some other circumstance that required them not to be here or did not permit them to be here, you would have taken their place. And alternate jurors are so important to us because of the gravity of this case and how long it's been around and how long it takes to try it. For that reason, we had 4 alternates, which is probably a record for me. Normally I have 2 or 3 at most, but we went with 4 just because we wanted to be sure that we would conclude this case. So that's why we had 4 of you. And we got lucky. We didn't lose any jurors. But the whole point of me explaining that to you is to sincerely express on behalf of everyone here how appreciative we are of your time, which is an extremely significant amount of time. I hope you found the experience rewarding and educational at a minimum. I always feel a degree of guilt on my own behalf because you were alternates that didn't serve, but it does conclude your service. I do want to advise you of a very special privilege that you have. Even though you are not involved in the deliberation process and deciding the guilt phase or this part, you still have a privilege not to speak to anyone should you wish. No one can compel you to speak about the case other than by court order. And you should realize that in the case of this magnitude, with so much attention paid to it, people may be curious or they may seek to find fault with the process. Realize that before you decide whether to exercise your privilege not to speak about the case. But you are allowed to speak about the case. That's the whole point of that. The rules governing your conduct no longer exist. You're free from all of that. But you're free, with my thanks on behalf of the United States and the state of Florida. Thank you so much, ladies. You are free to leave at this time. The bailiffs will assist you.
So the 4 ladies who were alternates are now excused. That's why he said ladies. They knew they were alternates. They were alternates during the main trial as well.
If the lawyers could check on the objects to go back, the items and evidence, I think they're the defendant's photographs, right? Yes. And the verdict form and the instructions are there, or?
Are they going to send like the framed pictures back?
Yes. There's one for every person.
Couple things I want to bring up. First of all, defense was not just trying to reach one person. He was speaking to 5 people. That can't be easy, right? It cannot be easy.
Just want to make sure the victim impact statements are just court's exhibits, not going back to the jury. Okay. Very good. Okay. So it's just the defense photos. Okay.
In the guilt phase, all they need to do is find one person who will vote not guilty, and then you've got a hung jury.
So we will be in recess awaiting the jury's decision in this case. And, all right, everyone be at ease until that happens.
At ease.
We'll go off the record.
Been standing at attention this whole time, so thank you. He's trying to reach 5 people, because if he only reaches 4, then the other 8 can vote for death, and in Florida, that's enough. And the recommendation would be the death penalty. He has to reach 5 people. And he chose maybe I can offend them enough that they'll be on my side, and I will insult them enough that they'll agree with me. And last but not least, I'm going to guilt them into joining my side. Now, I've got some thoughts on this. First of all, the jury is called to serve out of the community, right? And they represent, in a way, they represent the community. We do not, you don't volunteer here, okay? You don't volunteer. You don't apply to be on a jury. You don't say, hey, pick me. I'd really like to do it. I've got some good insight on that one. I think I could be a good juror. You are summoned to court, and you can be incarcerated for failure to respond. You are picked as a representative from the community to serve in the place of everybody else. And you're picked to do this against your will and under threat of incarceration. For the defense to insinuate that individuals outside the confines of the courtroom will shun them for their decision should they choose death penalty on the vote. And he did that. He said, when you go out of here afterwards, you're going to be talking to your friends, and they're like, oh, you were on a jury? What did you do? And he said, well, I voted for death, for the death penalty. They're going to lean out, right? They're going to lean out. No one's going to be like, oh, good job. He's saying people will reject you. People will step away from you. They will distance themselves from you because of this choice. This is shaming the juror, and it introduces an unfair and inappropriate influence on that juror. That juror should, as a representative, be able to view the evidence in court and make a decision according to their conscience, saying, I have weighed the evidence and here is my input. It is what it is. But instead, they add this, people won't like you if you do it. You can almost hear them now. You know what the names they'll call you if you do this? This is unfair. And if you think that maybe this should be all right because, death penalty is something serious, let's flip that for just a minute on its head, right? Let's roll that backwards and say, what if the state did the same thing during the guilt phase? Don't you hear the roar of that crowd calling for this man's life? Do you know how mad they're going to be if you do not convict? This is not fair. This is an unfair situation to put those jurors under. It's not right. Whether you're for the death penalty or not, it cannot be part of the decision. The jurors should not worry about what people will think about them going forward as their primary, concern. Instead, they just need to weigh the evidence. It's wrong. It's wrong both ways. I think it was wrong for the judge to have allowed it. It was wrong for the prosecution to object, and it was definitely wrong for the defense to bring it up. Rob, I'm sure Rob and Ian, I'd love to hear it because I would love to hear a take from lawyer, Ian, Kurt, Rob, Emily, the great ones who, from the defense standpoint, right? From the defense standpoint, there are some great arguments that can be made for defense, especially in a death penalty case, that can appeal to the masses, that can appeal to individuals. We've talked about the one briefly about just the financial burden that puts on the taxpayer. Okay. Why not argue that? You've got a defense attorney who has basically no mitigators. I'm not sure if Amber means to do this, but I'm getting a call from all of my mods at the same time. Hey, all the mods, you're live on the air. Hello? They hung up. I don't think she meant to do that. I think she pocket dialed me. It was a mod group call that was coming in. Can you live with your recommendation is weightier than how expensive this would be. It is, but it's the wrong weight. It's an inappropriate weight because the other way is, can you live with not doing it? And it's inappropriate for the state. It's got to be even. We've got the whole scales of justice, right? The swinging scales of justice. To unfairly slant them in one direction or the other is inappropriate, and it's wrong. Okay, we've got another call coming in. Hang on.
Call from Maddie.
Maddie, my friend, how are you doing? Long time no talk.
I am flabbergasted.
Your gast is flabbered.
Yeah, you know me. I lean defense.
Mm-hmm.
I mean,
we should.
Know me.
We should all lean defense.
But put it bluntly, what the hell was he doing? Like, I feel attacked, and I'm not sitting there. Like, I mean, was he going for an inefficient counsel? Inefficient counsel?
That thought crossed my mind. That would be very bad for a lawyer. Like, I lose your job type bad, to intentionally throw a case by giving your client ample room to have an appeal on inefficient assistance of counsel. That's terrible.
There's going to be appeals. There's going to be appeals for, and you were talking about things that he could have brought up. That's one of them. He could have gone, if you do find him guilty of the death penalty, unfortunately, the family is going to have to continue going through this because he's going to be granted appeals for decades.
Yeah.
And, he could have played into the sympathy of the families. Not, everyone's going to look at you like a killer.
Yeah. I don't know. Maybe I'm offended on this one just because, first of all, I've never been on a jury. I'd love it if I got picked. I've never even been summoned. Don't know why. Call me lucky, call me unlucky. That's the case. But I have so much respect for the process that calls people out of their jobs and their regular life and has them put everything on hold and make some of the most important decisions in our society has to make. I love that it is, in fact, a jury of your peers. It's somebody, we're not getting a team of lawyers, right, who are going to debate, or a team of politicians who are going to debate about our case, or even a team of judges. We're getting a jury of our peers, and we have people from every walk of life and background is why we have this. And for this defense lawyer to get up there and say, I could do your job better than you, I know more. You guys are, who are you to make this call? Who are you? Use some humility. I recommend humility.
Yeah, it's like we're a member of the public. We're a member of this community that this tragedy happened in. So we have the right to stand in, for lack of better terms, judgment. But it's I don't know. And I've been called for jury duty several times, but I always never get called to actually come down. But anytime I get summoned, it's you pick up the phone here in Arizona. You pick up the phone the night before and you call, and it tells you if you're supposed to come in or if not. And I always get the recording. Thank you, but your service is not needed at this time.
Thanks, but no thanks. Don't call us. We'll call you. Yes, that's the rejection letter we don't like. But
yeah, well, I mean, I did mock trial in high school, so I and law school, so I have the idea of what to happen. Plus, I mean, I watch trials on a daily basis for fun, so I probably
we're all nodding. Yep, we do that. What was probably the worst for you? What was the worst argument the defense lawyer made in his closing? What was the most offensive part for you, do you think?
Just the act of comparing the jury to Jose himself. Like, if you find him eligible for the death penalty, you're just like him.
Are you premeditating murder yourselves? Right? Doesn't that?
I'm like, whoa.
Yeah, pot, meat, kettle, right? Yeah. For me, it was when he brought in the God complex. He's like, perhaps some of you are tempted to be like, yay, finally. I've always wanted to kill someone. I just never had the chance, and this will be my chance. I get to pull. Seriously?
It's not like they're sticking the needle in or whatever means of final judgment they decide.
Yeah, for $20 an hour, I'm sitting through this, hopeful that at the end I'll get to finally choose to take somebody's life. It just didn't click. It didn't click with me. But
no, the whole thing was just. And I have sent it to Peter, by the way.
Yeah,
I have sent today's today's link and
Awesome.
email to Peter.
I'm sure Peter's gonna.
'Cause-
Peter's in Florida, so he's close
I
to this.
know.
I know there are some times where cases are so close that he's like, I've got to be careful, right? Because I practice with these judges and I practice with these lawyers, and I respect
Sure,
that.
and I would understand that.
I'd love his take on that as well as some of the out of state.
Oh, I know. I also sent an email to the Defense Diaries and to Bob and Allie. I want to hear what they have to say because they are criminal defense attorneys.
Yeah. And
So
maybe
I would
maybe
love
they'll
to
take a
hear
different take. There might be a defense attorney out there who says, if it works and it's allowed, there's an argument to be made there. The judge allowed it. There was an objection. The judge allowed it. And if it comes back with life in prison, good job, right?
I guess you didn't notice in the chat. That's all I was screaming was objection, objection, improper argument. I'm like badgering the jury, whatever. He's being an a-hole, whatever.
What's this spectrum of death? I mean, let's forget all about the box and the balloon and the lean in, lean out. What spectrum of death? It's like you've got everyone imagine, close your eyes. Oh, imagine the death came through the door. Dun, dun, dun. Here he comes. It's like, was it a boy or a girl? It's like, seriously? That's your first thought?
Yeah.
And was it a grown up or was it a little baby death? Just wild moments.
Yikes. I mean, that's just...
I'm going to go back and watch this. I might actually go and cut some of the highlights or lowlights, depending on how you want to call this, curious moments and assemble them in a single clip. But
you could even go back to his penalty or guilty face closing and chop
there were a lot of similarities. I mean, that was the end of that is like, you guys, I don't know what to say because I don't know what to tell. Well, that was his open for this part. He on every time he's gotten up, he's just been a firecracker, just wild, just out there. But,
yeah, and it's funny watching the prosecutors while he's doing it. They're trying not to crawl under the table. Like, are you kidding me? Are you really saying? I mean, we thought Donna Adelson's closing argument was bad. This is even worse.
I've never heard a jury attacked and belittled so much. I've heard it happen. We've heard them. But I've never seen it be the whole focus of the closing like this, just from start to finish.
And it was, 45 minutes worth? I mean, my mother never attacked me that bad growing up, making me feel, that little.
I'm reading comments. Sorry, I'm laughing, Maddie. I need a Spectrum of Death soundbite.
Oh, no, I know. I got you.
I wonder if the jury is looking. I mean, a couple things can happen, right? Obviously, if you push the jury away, sometimes they push back, right? And if you attack the jury, they've already done the convicted thing. That decision is made in their mind. They're not second guessing, thinking, well, maybe he didn't do it, right?
No, they're like, he did it without a doubt, and 100%.
Their mitigating factors are a kindergarten diploma, okay? And my mom thinks I'm cute, and you're looking at that and just like, seriously, no, he's got more than that. Obviously, he's got some, he's a family man, unless it's not family, and then it's not.
Officially,
he likes kids unless it's his that's not born.
Yikes! Plus, officially, until now, he wasn't convicted of any other crimes. Yeah. So, except for the one that he. Yeah.
The defense fought and successfully won, so the jury didn't hear that he said that he has done this previously in another jurisdiction.
Sure, but that's still.
What's with him saying, I knew you were going to find him guilty. I knew he was guilty. I knew he was guilty all along. Then why did you say it was his mom that did it? Or Eric? Why were you? Oh, man.
Oh,
Maddie.
All right.
What's it come to?
I will let you go, brother.
Thanks for the call, man.
I just had to get that off my chest because the whole time I'm like, I have got to talk to her, Scott. Yeah. I've got to talk.
Yeah. Maddie, it's good talking to you again. Good to hear you. Be
safe.
Buddy. We'll see you. Bye. Oh my goodness. Wow. I've never heard the jury attacked like that. That was just bizarre.
Call from misconduct.
Misconduct. Long time no talk. How are you doing?
I'm good. How are you?
I'm doing fabulous. Although I can't remember where you're calling from. Is it
near Stansted Airport in England.
in England? Okay.
Not far from where you spent some time.
Right. Wonderful.
Yeah. Okay, so I'm quite judgmental.
Excellent.
I'll put that out there.
Excellent. Let's hear your thoughts.
Pardon?
Excellent. That's wonderful. Let's hear your thoughts.
Is it excellent? Probably not. How has this lawyer been able to give the old emotional thing? You know, we've been told so many times, we've been shown so many times that you can't use emotional manipulation for sentencing.
You shouldn't, but they're allowed to do things that really do pull on the emotions. And that's why the prosecution got out and said, hey, emotional decisions are bad decisions. Don't make an emotional decision here. That's why they got in front of it. They knew that there was going to be, some pulling on the feelings of the jurors. I thought it was going to be more of the sob story heartstrings. Like this will break his mom. But instead
I don't like it.
Yeah.
Yeah, I don't like it.
Yeah.
So that was really it, because we all know he did it. We all know he's a monster. And yeah, I'm not really keen on the closing for the defence.
It was different.
That's all I'll say. Not get banned.
It kept my attention. It kept my attention. It was different.
Yeah.
It didn't follow the what I'd call the rational thought process many times. There's so much that I'm just like, every time it's like the hand motions for shove the balloon up the box's bottom thing. What are you doing? I'm like, I don't follow your analogy here. And I looked I brought a box just to show you. Look, it says on it. It says this is my bottom. It says on this box. Look,
that's your bottom.
That's where the balloon goes. Apparently, this is my bottom. It says.
Oh,
I got this box in Amazon today.
Doesn't look like that.
That's where the balloon goes. In case you know.
You know, I don't have a great bottom, but I'm glad it doesn't look like a cardboard box.
Oh man.
Look, yeah, it seems a little bit of Adelson, doesn't it, Donna?
That was a wild one too. That was
a little bit of deflect
the
blame.
Yeah.
All right then, mate.
All right.
Very happy to speak to you.
Always a pleasure.
Love you lots.
Cheers.
Been a member for
long time. Long time.
Yeah.
OG. Yep. Thank you very much.
OG.
All right. Have a good one. We'll see you.
Night, babe. Bye.
All right. The phone line's clear now. We can take another call. I know another one was coming in right there. Donna's wasn't offensive. This closing was offensive. It was. I think it was offensive because it attacked the system, the entire system.
Call from
AWOL.
AWOL, one of our favorite callers, always with a hot take. How are you doing, my friend?
Not much. Just got home from work. Thank God. Made it off the road safe in one piece.
That's always the goal.
Yes, it is.
Did you catch all the defense closing?
Yeah, I was lurking since 8:45 this morning. I just can't chat. I did a couple of times when I was waiting in the port, but not when I'm driving.
Yeah, appreciate that. We want you to be safe so you can make calls in the evening.
Yeah, that's what I do. So I have all my thoughts in order. I'm against death penalty for different reasons because I just don't trust it. I said it in chat. Imagine if Karen Reed was facing VP and knowing that investigation, do we now trust? What if the jurors, now that we know how the investigation happened, what if the jurors got it wrong in her case? Yeah. And now this is what she got. This is why I'm against it. But
yeah, there are no take-backs after you kill somebody.
There's no take-backs. And also, I want to say, if what he did was heinous, I put a disclaimer in the chat. It was heinous. He should rot in prison. I don't believe him. He's not innocent. I'm sorry for the victims. I feel bad for the family. Yes, of course. But if you truly, truly want him to suffer, you would not want VP. Florida's average to house a VP inmate is around $54 million a year. Why? Because they get better accommodations, better staff. We pay for all their tablets and TVs. You get to Netflix and chill. You're not in general population.
That's 54 million. That's for the whole population, right? Not just for one.
No, I think that's per inmate.
54
or
million?
Maybe, you know what, that might be, that might be for the population of, yes, for the inmate, yes, for the inmates, yeah, DP versus regular inmates. But if he got life without parole, he has to think about what his charges are and what he did. DP, he gets to sit in his cell by himself, and then one day they're going to knock on his door and go, hey, time for the needle time. When life without parole, every day he has to wake up and think to himself, is today the day that I get got by another inmate? And if he doesn't get poked up at first, we already heard they're putting money on his books. They will shake him down for the rest of his life because of the baby. So is it more traumatizing to him? Will he suffer more dealing with that type of justice compared to sitting in a cell like Wade Wilson or Kohlberger and not be afraid of anything?
You know what I'm going to say here, because I've said this many times before. If I could eliminate all forms of prison justice, I would. I think it's wrong, right? I think that is, deserve it or not, society has a penalty that we put on somebody when they do something wrong, and I think it's wrong to punish them again or to have prisoners be allowed to or be encouraged to punish someone further. I'm against all forms of the abuse that happens in prison. Prison justice, for me, that just, it's wrong. But which one is worse, are you saying? Living, not knowing, like you say, general population, the threat of being in general population would be a worse outcome than being on death row?
100%. My friend works in the state prison. State prison, he did county jail, which he said was even more crazy. Yeah. But he is in a state prison right now. What I am saying, I don't believe in a jail justice either, 100%, unless depending on the charges. Women and children, my take might be different if you cause harm to them. But that's my personal opinion. If you harm a woman or a child, I could debate that for a while.
He checked both those boxes.
Exactly my point. So even if we agree that it is not right, we also have to agree that it is actually a thing, though. Even though we can want to wish it away or will it away, we're not going to. It's an actual fact. It's there. So I just don't want to let my emotional anger of what he did give him a way out. Because if I really felt that strong that he deserves punishment, general population is a harsher punishment. So why give him a hotel room?
Well, let me say this.
Not me, but if you truly want him to suffer, DP is not the way. If you're so angry, not you, but if someone's feelings are so angry, DP is not the way to go.
So couldn't you make an argument to say, why don't we give him the thing he's fighting against? Because clearly he doesn't want that. I mean, yeah, he might be doing the whole reverse psychology on us and want to be on death row and saying, please, whatever you do, don't put me in life without parole. I'm scared of Gen Pop. No, we might have that, like in Koberger's case. But the fact that they're fighting so hard against it, doesn't that mean that that's the thing he doesn't want in some way?
And that is I'm so glad you brought that up, because I said that earlier in chat. I don't understand why the state fights for DP other than if the family wants it. If the family wants vengeance in that form, then let the state do it. If that's what the family wants. And against with a defense, why would you would want, if you were the defense, you would want DP. So by the time your client, can't even put myself in a state of mind to be facing these type of things. But let's say for thought experiment, I would want DP. I don't want to walk around with these people and have to worry every day. Getting my TV, my commissary, I get my own bathroom, I get my yard time, I get extra protection. Mm-hmm. I don't have to work. The government pays for everything for me. What kind of punishment is that? And then I get to go away one day peacefully with an injection instead of every day for the next 70 years.
I don't think anyone who hasn't served time can fully appreciate the mental impact of being incarcerated, of being locked up, literally being in a cage. I think that does something to someone. That does something to anyone.
Definitely.
So I don't think that barring you're in some ritzy, fancy dorm room style, you can come and go as you please, prison. I think punishment is real. That being locked up and not having the ability to say, I don't want to do that today. I don't want to do that right now. Someone else controlling your life in every means. I think that's soul crushing. But yeah,
yes, especially if you're in there for, that's all. Yeah. I'm just trying to wrap my mind around as if DP is worse when it's not. And people could, I don't know if they have to do some research, go down a rabbit hole, contact anybody they know in law enforcement or in DOC. Documentaries, Google documentaries on the systems in prisons and how it works. There's a lot of them. You come to realize, oh wait, they got it good. Yeah. So if you truly want vengeance, then I don't know if that's the way to go. Yeah. But again, there's a butt for every chair. So I'm not saying I'm right. I could be wrong. I may be wrong. I don't know. But it's just a thought experiment.
I found the argument the defense has already made about, look how many states don't have the death penalty, right? I found that interesting. Because my response, and I think I even said it out loud, is then go commit murder there. If you don't want to face the death penalty,
I heard you say that.
Why don't you choose a state that's more in line with what you think should be fair? But as a society, we do set rules based on where we are. We call it states. Geographically, we set these rules, and these are the rules in Florida as they stand right now. You might not like them. They might change over time. They might get rid of the death penalty before it's time to, carry this one out. We don't know.
I agree with you. I heard you say that before. It was like almost 45 minutes ago I heard you say that. And you were right. If you don't like it, don't commit crime here. Yeah. Because these are the consequences. So I agree. I agree with that aspect of it. But I chewed your ear off long enough. Chat's probably tired of me already. But I love you all. Everybody have a good day. Let's see what happens later.
Hey, Walt, thank you so much. We'll see you, man.
All right.
Bye.
Love you guys.
Bye.
Bye.
All right. There's a butt for every chair. Love that. Let's see. Yes, made the jury very uncomfortable. Love this chat trying to change the definition of a word just because of who is deciding it. Are you talking about murder? The Hellraiser and Angel, I probably want to hear what you're getting at here. I'm sorry I missed your previous comments. I think the defense lawyer raise this, if I understand you rightly, and I might be wrong on this, so forgive me if I am, but he did raise this when right at the end when he said, "Let me read you these definitions," and he starts with the definition of murder. All the forethought, preparation, deciding to kill. How long the thought process to be there, and he's trying to relate that to the jury. And he actually did reread it and then insert the juror instead of defendant. There's a difference, though, and I think it's a powerful one, because in those rules that spells out what is murder and what is not, it specifically lists without authority or color of law, things like that. Those are listed. There's a point where society has granted this ability to the judicial system, to the process, and it's entrusted in the jurors. It's very different. I think it's very different, and I think it's as long as the state has voted for that, as society has voted for that, I think it's okay. I'm okay with them banning it, though. I mean, I'm fine with states that get away with it, that do away with it. Maybe I misunderstood you, though. I apologize. Let's see, someone may make the argument sanctioned murder by the rules. It's sanctioned killing. It's definitely homicide, but it would, for me, it's in the same light as self-defense. Only self-defense is a decision made by one in the moment, and the death penalty is a decision made by several after the fact. All right. We're back again.
Call from misconduct.
Misconduct. Welcome back.
Yeah,
Long
I'm
time
back.
no talk.
I'm back. Yep. Okay, so my question is, if the majority of us peeps that just follow true crime and feel like justice or injustice, what's the majority? I know you don't like doing polls.
As far as, are you asking just about death penalty, doing a poll?
Yeah.
I'd be happy to do that. Let me end the poll we have going right now. If you haven't voted, just 1 second here, we can do that. Because I think it would be. I'm just predicting here. I think the results would be sort of in line with what the states currently show as who has death penalty and who doesn't. I think it's going to be similar along those lines. So 50%.
Oh, I apologise if I've repeated something.
Okay, and put in an indifferent option. Laura, let me do that just 1 second. The poll we have right now has 1,135 votes. How long will it take the jury to recommend a sentence? Under an hour has 37%, 1 to 2 hours, 46%, 2 to 4 hours, 14%, and they will set a new speed record with only 3%. So I'm going to go ahead and end that poll with, it looks like the numbers should be in chat here in just a minute. Do you guys see these numbers in chat right now? No? I'll post them in case you don't. Hang on. Wait.
I need to look because I'm on the phone.
Yes, they see them. Okay. Well, I just posted them again, so there they are with no spaces. All right, I will do another poll, and it's going to be general. It's not going to be specific to Jose Soto-Escalera. It's just regarding the death penalty, and I realize we have people who are outside of the country, in different countries where the laws are very different, and that's okay. Feel free to vote as well, because we're just gauging on a personal level where everyone stands.
Oh, believe me, it's not about what my country does, because I honestly know more about the US law system than I know about the UK system. Yeah.
Okay. The question.
That's all I'll say.
The question is: do you support the death penalty? Yes, no, or I am indifferent. You can just put it in chat. You don't have to out yourself in chat if you don't want to.
Yes. Yes, I do.
All right, wonderful. With polls up, you can vote now. Misconduct, thank you very much. Appreciate the
Thank
call
you.
once again. Don't wait so long. Don't be a stranger.
Thanks, mate.
We'll
Bye.
see you. Bye. Melissa Kyer, welcome to the gallery. And I saw somebody up here. Hang on just one second. Jenny H. Jenny said some really kind things. Just one second. Let me find that comment I had just a minute ago. Scroll. She said, this is my very first time chatting on this channel. Melanie Little sent me, and I'm loving it. Just subscribed. Jenny H., thank you. Thanks to Melanie Little as well. We had a lot of muffins, cupcakes, muffins were broken baker. They're muffin tops. I'm getting my pastries confused. Join us today, and it's wonderful. I appreciate it. There was a huge influx of watchers, probably close to 800, 900 of them showed up when Melanie rated us, and you guys stuck around. It's amazing.
Pamela the Camel.
Pamela the Camel. It's been a bit since I've talked to you as well. How are you doing?
Hi. Good. How are you?
I'm just fabulous.
Awesome. Hi, chat. I wanted
They said
to
hi.
tell you. I can't remember if you covered this case or not. It's been a couple years. There's an inmate in Florida that's already on death row. His name is Steven Lorenzo, and he pled guilty to his charges. He did very heinous, atrocious, and cruel things to men in Florida years ago.
Okay.
And pled guilty. And then when it was time for the penalty phase, he wanted the judge to give him the death penalty.
Okay.
And this was Judge, what was his name? I can't think of his name off the top of my head. But so the judge gave it to him, and now they're doing the post-conviction stuff. And he recently he wrote a letter to the judge asking the judge to get rid of all of his post-conviction counsel and to quit all of his appeals so that he can just be put to death. Because
begging for it.
Yes, because he believes in reincarnation and he thinks he's going to get a do-over.
It's interesting. We did not cover that case. Judge Christopher Silva. I think we have covered cases with that judge.
Yeah, I love that judge. Yeah. But yeah, there was an update about him recently that I saw, and I was like, "Oh, we're talking about death penalty. I got to bring that up because it was super interesting to me." The guy's really weird.
It's definitely an outlier amongst all those on death row. You've got a few people that are just that sort of stand out. I mean, Chad Daybell writing his letters, and this guy begging for, can we speed up the process, please? I've been waiting forever.
I want my do-over, Judge.
But
a weird situation.
Very interesting.
I thought you and chat would find that interesting, and I wanted to share. So
I wonder, from a legality standpoint, I know some of those appeals are automatic, right? That they literally, and this goes to the issue that AWOL brought up. We don't want to put the wrong person to death, and some of these appeals are designed just in case, if for some reason we got to this point and we've made a mistake, right? This is the off ramp to say, okay, we don't continue down this road. We can stop right here. We can acknowledge our mistake, and we won't go down this path because we don't want to put the wrong person in prison, let alone to death. And so I don't think he can just waive those and get them to go away. I think the process has to be followed as much as he'd like it to be done faster.
I'm interested to see what happens with it, but yeah.
Interesting stuff.
Yeah.
You got plans for tonight?
Working
I'm not
overtime.
asking you out. Oh, I was going to say, I'm asking if you're going to be on the podcast, coming to the podcast tonight at 8 p.m. I was just trying to plug it, but it sounded like I was invited to dinner or something.
I'll be in chat.
Okay, wonderful. Thanks so much.
Talk to you later.
We'll see you. Bye.
Bye.
Sometimes I need to just think what I'm about to say before I say it and then not say it. Jenny, thanks so much. This is a wonderful community. I think all of LawTube, for the most part, is a cut above the rest when it comes to the communities on the internet. But we do have a little special place here, and welcome. You're one of us. Glad you could find us here, and thank you so much to Melanie Little for making it possible. No, not at all. Happily married. It just, the way it came out, it just sounded wrong, and I had to immediately, clarify. We had a lot of people said under an hour. We're about 44 minutes into deliberation right now. I imagine the paperwork is probably going to take 10 to 15. Just to make sure you get it right, because I think you only get one copy, and you don't want to mess it up. But the rest, they've already got a foreman, right? I don't think they have to elect a new foreman. They already agree on at least one topic, and honestly, the decision to decide whether or not there are aggravating factors, it's pretty much a given, right? You've got two committed at the same time, and you've also got the additional one that the child was under 12. Being not yet born, that's the aggravators are there. Whether or not there are additional ones, I guess they might be doing all the paperwork. As the judge did counsel and say, don't make this a rash decision. Don't make it quickly. This is serious, and I appreciate him doing that. Even if the jurors all unanimously said, we're ready to give the death penalty at the time they convict him. If they thought that at the same time, I think it's the right thing to do, to go through the process at least, just to check themselves and make sure that the process was followed right, instead of an emotional, let's carry this all the way to the finish line. Big push. My state has the death penalty. They've only executed 4 people since 1976, I believe. That's one of the reasons, BM, one of the reasons a lot of people are saying, hey, let's get rid of the death penalty. First of all, it costs so much, but we're just not doing it, right? It's a de facto non-existent punishment, and it's getting harder and harder to do it. Even the the methods that we used before, some of them can't be used now. The drugs that they're using for lethal injection are getting harder and harder to source, as companies say, I won't make that and sell that to the prison. I don't want my brand on your version of our product. That's not what we made it for. But let's see. Somebody said I won my legal case in high school against death penalty. Not sure I can even answer the poll. Yes. I would recommend, as the poll's still going, we're going to close the poll out in just a second. I would recommend for anyone and I'll say on any topic, to try to argue the other side sometime. Just as a theoretical, hypothetical situation, reverse the cards and say, I'm now on the other side. What is my strongest point? What is my, what makes sense? What is the rationale here? It might not change your mind, and it probably won't, but it might help you understand the other side a lot better. And probably that process will help us, as we all try to live and work together. Not necessarily make compromises, but do better in living together and associating with each other. It's a good habit to get into. All right. Podcast tonight, 8 p.m. Not Relevant Podcast. Thomas and I will be here talking about things that are not relevant. For those that just joined and show up for the first time on the podcast tonight, it is a very different show that we do on this channel. And the reason we do it, it's very lighthearted. We look at a lot of funny news stories that have happened around the country. It's basically a kickback, very unscripted, fun time together. And we talk about things that are not relevant. Because every day, all day, talking about some of the worst of society, as we do when we follow true crime, can get heavy. And we realize that it's good to take a break from that occasionally. So we do that every Thursday at 8 p.m. Please join us for that. And don't unsubscribe just because we tell pathetic dad jokes. Both Thomas and I are dads, and we tell dad jokes that are pretty sad. But give us a chance. Come back the following day. We'll be back to true crime on Friday. Let's see. It's a palate cleanser. Yeah, it is. What times are we in? I'm on the East Coast of the United States. I'm in North Carolina. Greenville, North Carolina is my general area. About an hour and a half from the ocean, about an hour and a half from Raleigh, about an hour and a half from anywhere you want to be. The only thing that we have local right here is Mr. Beast, who's in my hometown, basically, lives here. So your kids might know who that is. I don't watch much of his stuff myself, but my kids like it. Go Pirates, right? ECU Pirates, who put on a good show but got beat last week. Let's see. It's always on Blue Replay Crew. Past my bedtime. Let me keep an eye on what's happening with Jose Soto-Escalera to see if we've got any movement from court. Let's see, I'm not seeing it. They spent 1 hour, 59 minutes, and 54 seconds on a different, oh, that's a different one, sorry. They've gone 37, that was 8 minutes ago. Yeah, I think we're right on the timer. I almost unsubscribed due to the dad jokes. Stacy, you're there every week. I know we've hooked you. I'm impressed by the debate in the chat. Most all have great points on both sides. Aviator, I just saw what your acronym was for. Hope you fly planes. You can tell us all about it. This chat's amazing. We have in this community, just who are watching, we have everybody from lawyers who watch. We've got professionals, law enforcement are part of us here. We've got obviously professionals in many different fields, some even as far as what you would call rocket science. A lot in the medical field, a lot in the legal field or legal adjacent field, working with the justice process, some with victims, some with defendants. It's amazing. I can basically be confident that at any time with any topic that comes up, there's someone in chat who knows it better than I do, which I love because I learn a ton from all of you. Any court for us to watch while we wait? We could. I was going to wait for the first hour here with the court just to see if something came quickly, and then we might try to jump. I don't remember how long the jury time was on the first trial. Yeah, I thought it was short. I thought it was under 3. Hey. Oh, you guys, look what. Hey, look at this. My wife's been cooking. Oops, I just completely broke my camera. There we go. Autofocus. My wife's been cooking, and she makes rolls. I'm going to get it nice and close so you can see. Look at this. Steaming buttery top. Delicious. Oh, it's so hot. Let's see if I can show you the steam. It's fogging up my lens. Hang on. I'm not sure if you can see the steam. I can because it's lit from that side. Oh, my goodness. Melts in your mouth. My wife, I challenge you. No one makes better rolls than she does. Nobody. That's good. That's really good. All right. And she does cinnamon rolls for when, you want the extra calories. I am super spoiled. I married up. The secret to making these rolls as beautifully as she does starts with the wheat grinder. I mean, she makes them from scratch. I think Mrs. Ray does share her recipe over on her channel, Homeschool Ground Zero. If not, I'll have her do that. Smell-o-vision needs to be invented. Taste-o-vision would be even better. Bet you can't eat just one. I can't. Yeah, she does grind wheat, and so the flour is hot when she starts using it. It's so good. I'll order 2 dozen, please. I could send them to you, but I can't guarantee they will be as amazing as this when they arrive. Grind wheat, not weed. That's important. Yes, subtle difference, but very important. Oh, look at this. Another smile, another package. Hold, please. Hold, please. Let's see what came in the mail today. We have gaffer's tape, 2-inch by 30 yards. This is important. This is what you use to hold cables down on the ground so nobody trips over it on long runs and microphone cables and things like that. It's the black tape you see in court all the time. Going to need that this weekend. We have Cat 8 Ethernet cables, 2 6-footers, and that's all. I've got 2 10-footers that are also going to arrive later today, which I need for my my pan tilt zoom controller and the power over Ethernet box. What's the difference between gaffer's tape and duct tape? The difference is gaffer's tape does not leave a residue. It's easy to tear, and it's a cloth feel instead of a plastic feel. Let's see, we've got another call. Hang on a second.
Call from
Bree.
Bree, how are you doing?
Hi, how are you?
Let me just say, I'm so glad you called because now I can finish my role while you talk. How are you
Good. Actually, that's what I did it for.
What's on your mind?
And listen, I need her rescue. Or if you can just ship me some raw dough, I'll just bake it in my own oven. It might still not be as good, but
that's an idea. All right.
Right? Just ship them out. Dry ice. We got this. I'll be the first guinea pig, so that way if it doesn't come out perfect, then we know how to fix the recipe for the other members. I volunteer as tribute.
I can just nod because I'm eating.
Yeah. So I was calling because it's really crazy because I live out in New Mexico and we don't have the DP out here. And they had a kid. I think he just turned 18 now. He was 17 maybe. But they're going for federal charges to charge him, to give him that charge because he decided he needed to blow off some steam and pinged a rideshare driver and just unalived the rideshare driver for fun because he needed to release some steam. And then during the interrogation found out this may not be the first time. So it's just crazy to see this running through. I'll send you the link, but
he needs to be banned from Uber.
Yeah, 100%.
First of all.
Yeah.
That is
but
crazy.
But they are, and he was mad. The interrogation videos are just, they're sickening. Like we've seen some, we watched Letitia in all of her lives and everything else, whatever. He was like, oh, I just wish he would have been bigger because I want to take out, like the mentality that he has is just, you cringe. But because it's not an option here in New Mexico, they're charging him federally because of the fact that it's a rideshare operator now. And so they can. And so
it's
they're
interstate
looking at
commerce
going
or transfer.
Mm-hmm.
Yeah, okay.
So they're looking to use that against him now so that they can charge him with that. So it's crazy that this comes up, and even in places you don't think you're going to hear about it, it can come back, and it's, I can see both sides of both arguments, whatever, but sometimes when you just go take out some person who's just trying to make a living just because you want to blow off steam, it's just there are just certain things in life that are not okay.
It seems like we occasionally get a case, and we've had a couple of them, where the argument has been, if there ever was a reason to have the death penalty, this would be it, right? So we get that. And then every single time in the case, we get this argument at the end that's like, but no, what good does it serve? Is it just to make you feel better? Because it doesn't really change anything. It doesn't bring the victim back.
Yeah.
We've seen some movement. Somebody probably kicked the tripod. Well, thank you very much, Bree. Appreciate the call. I got most of my role eaten.
Well, good. So that's what I was here for. But I'll send you that if it's something, not that you want to follow that, but just for future, just because of since it's not here at state level, but it is federal level, to kind of follow the process of it. I'll send it over to you guys.
Cool. Awesome. Thank you so much. Appreciate it.
I miss y'all. Thank you. It's fun. I miss you guys in chat. You are amazing.
All right. See
Love
you, Bree.
you all.
Bye.
Bye.
Bree's awesome. Mrs. R.A.'s channel is Homeschool Ground Zero. She has not. Homeschool Ground Zero. Exclamation point MRS. Should get it in chat, I think, for the mods. But she hasn't put any new videos up lately, but I think she might do one here soon. So there it is. Thanks, Josh. There's a link to her channel. It's mostly, hey, look who just joined us, Broken Baker and the Muffin Tops. They came right as I'm finishing my amazing dinner roll made by my amazing wife. So we've been rated by muffins and cupcakes today, which is just cool. I'm going to end the poll here. I know we're just shy of 1,000 votes on that, but we're also coming up to an hour. And the question here was about the death penalty. And the question is, do you support the death penalty? And it actually has some surprising results. Let me show you what these results are as we look in chat right now for those. It says that yes, 59%. This was higher than I thought it would be. I'm going to put it in chat again in case it goes too fast. 59%, no 21%, and indifferent a full 20%, which is remarkable. I thought it was going to be more of a. I thought it was going to be more yes or no. It surprises me that there were 20% that were indifferent, or 21% that were indifferent. But I thought it was going to be more polarized and closer as well. So very, very interesting. Sorry. Welcome, Baker Raid. Hello, Muffin Tops. We got to raid Broken Baker the other day, and he's returning the favor, as he always does. Wonder what Broken Baker's cinnamon rolls taste like? Well, we'll probably have to do a challenge, although one of us is going to have to fly somewhere to make that happen. Not sure who. All right. The poll results give him life without... Rocky, this is interesting. That's a great point. If indifferent votes is no, which I think they should, unless they feel strongly on yes, and that would only be on this case. Now, generally, well, let me back up. This was about the death penalty in general, and not specifically in this case. But if those same results came in this case, 59% yes versus 41% no would not be enough to recommend the death penalty.
Call from Hanging with Yins.
Hanging with Yins. Good afternoon. How are you doing?
Good. I have a question about the jury process, like when they're doing the death penalty deliberations. It's just like 8-4, but who decides when they stop voting? Like, couldn't you keep voting and keep retaking the votes until somebody gets I mean, isn't there room for corruption there?
I don't think it's the same as in the guilt phase. In the guilt phase, you have to have a unanimous jury, and so you're encouraged to attempt to find agreement. Right? In this phase, all they're told is to go back, determine yes or no, were these met? Are there aggravating factors? And then once that's done, look at the mitigating factors. And then individually, you cast your vote. I think once that vote is done, you can stop right there. There's no need to say, hey, we need more, let's see if I can convince you to, lean in on you and say, hey, come join us we have cookies, No, I don't think that you're going to have that sort of argument on the death penalty phase, where it's more of just a vote of where people stand. And it could be for a million different reasons.
So it could be just one vote, and then, I mean, but does that really spell it out that you can only vote one time? Do you know what I'm saying? Isn't there room for corruption there?
I think there's room for coercion, and I guess it might fall on the part of the jury foreman a little bit.
Okay. Yeah.
But really, once the vote's cast, I think they're done. I think they're done. I don't think the jury in this case or any other is really going to be. I mean, think how vindictive you have to be like, no, we need a unanimous verdict. We need to make a statement on this one. You know, we might have 9, but we want 12. You know, I don't think they're going to do that.
So they're only permitted to vote once.
Once each, but I think they can probably discuss it, and
Like
have an
they can only
informal vote, and then at the end they're like, now that we've all talked it over and we feel good with where we are, there's one vote.
Okay.
And that's
So
probably
this should be coming back quick. So right?
Yeah.
Okay.
I think so.
All right. I was just wondering that, because like what room is there for corruption with that? I don't know.
I don't like the word corruption when we think about a jury, because
I know.
The process of selecting them basically weeds that out, or weeds a lot of that possibility out. Is it still? I guess. Is it still possible? Yes, it's possible that somebody could, find them who they are in court and go to them, lean on them, or have money show up in their mailbox. We've heard all sorts of allegations from other cases about jurors, but pressure.
All right.
Yep.
All right. Well, that's all I have.
Hanging with the ends, I appreciate it. Appreciate the
Sure.
call.
Thanks.
Yep. We'll see you.
Bye.
Bye. If you were watching chat, you saw that my wife joined chat and posted the link to the roll recipe. They're called Lion House rolls. Let's see, another call coming in.
Call from Melissa Kyer.
Melissa, this is Scott. How are you doing?
Hey, Scott. How are you doing?
Doing great. You're live on the air. What's on your mind?
I know. You're such a tease with those darn rolls. Kind of makes me mad.
Well, my mouth's full, so I can't respond.
Oh, okay. I just wanted to say, as I've gotten older, my views on things have changed a lot. Because when I was younger, I would have said I was all for the death penalty. But I mean, I seem to think about more things when it comes to crime and people in prison and even religious stuff. I'm a very spiritual person, but I mean, I think about everything when it comes to, different obstacles in life. And it's just, I have changed since I've gotten older. And I don't know if that's a natural thing you do or if it's just me.
I think it's
because
natural.
I could not vote to convict or to kill this man. I mean, because I don't feel like that's my place.
I think that's great. First of all, I think that's great, and I think it is natural. In life, we have experience, right? When we're kids, we have to tell our kids, don't run in the road. Okay.
Yeah.
You rarely have to tell an adult that, right? Because they've either learned from their own experience or they've learned from other people's experience. As you age, you have experience. You have things that broaden your horizon and might add to your mindset and your thought process and your view, your outlook.
Exactly.
All that gets weighed in. That's why we say,
you know what?
with
when
age
you
comes
have your
wisdom.
grandbaby,
Yeah.
when you have your grandbaby, you're going to have a different mindset about how you raised your kids and what you do with your grandbaby. Yeah. Guaranteed. I've been there. I've done that. Okay. Not that I raised my kids badly whatsoever, but things come to your mind that didn't come to your mind when you were young.
Yeah.
Because I started having babies when I was 27, Mm-hmm. That's pretty young.
Yeah, I think all those experiences and the wisdom that comes from the years of experience is great, and I'm fine with that. I think if we locked down our positions at 18, whatever your thought process was at 18 and your outlook on life and your morals and everything else, we'd be terrible.
That would not have been good.
We've got to be able to adjust and learn and change and grow and incorporate other knowledge into our mindset. So great point.
Yeah.
I'm with you on that one.
I just had to get that off my mind because there would have been one point if I was young watching your show, I would have said, death penalty for sure. I couldn't do that.
Yeah, wave the pitchfork, chant.
Yeah, couldn't do that. And it's just not just that everything has a bigger scope now that I think about and rationalize and try to make up my own mind at this age, So it might be right, it might be wrong, but I'm happy the way I'm doing it now.
Yeah, that's wonderful. That's awesome.
Okay.
I know there's
that's
people.
all I wanted to say.
There are people in chat that say they've had the same experience and maybe reached a different conclusion, which is great. They might have been
right.
They might have been anti-death penalty and now see a value in it for society. So
True.
It's wonderful. That's what makes
That's
us all
true,
so great.
But one thing I don't agree with is all the killing in the United States. This has gotten out of hand. It's ridiculous. There should be peace. We should all get along. We're one. We're all Americans. Nobody should be fighting over this petty BS politics stuff.
I agree. And I think...
Or racial stuff or any of this. It makes me sick. But I pray about that every night.
It starts with me, though, right? I haven't gone out and shot somebody, but it's the change in the world starts with me, and it starts by me being respectful. And when I'm driving, how I treat other people on the road, how I treat people in the supermarket, trying to cut in line in front of people or whatever, how I treat people. I think that has a ripple effect, and a little action locally can change the world.
Because I do that too.
Yep.
I treat people the way I treat people with respect. And the way I want to be treated myself. That's just it.
Yeah. Sounds great.
Give people respect.
Thank you so much. Appreciate the call.
Okay. Bye, Scott.
We'll see you.
Bye.
Bye. Yahoo! No, just kidding. Thank you for that. All right. Let's see. So we've got more calls coming in. You guys have memorized the burner phone.
Behind Rudy's Fairing.
Behind Rudy's Fairing. Welcome. It's been a bit since we've talked as well. Doing well.
Yeah, it's been a minute. I'm in the camp for the death penalty.
Excellent.
But I'll caveat that with as technology grows, if your DNA, you're on video, you're on, there has to, proof positive that there wasn't evidence planted or any of that stuff. If you're caught on video committing a heinous crime or something like that, as technology grows, maybe the laws need to tack a little bit to meet with today's technology, let's say.
Okay. Are you saying that the standard should be higher, the proof should be higher to go with the death penalty? Now that we have,
yes.
Basically, we've got spy satellites that can watch everything now, right? So we should be able to have proof of pretty much any crime.
I'm not saying you need Big Brother, but I'm saying if you are, let's face it, everybody's got a camera on their phone. Your people are catching stuff. The police have body cameras. Every store has cameras. Like they put the TELUS thing together in Las Vegas, where they had him traveling from point A to point B, and the technology tracked him there. So yeah, maybe the laws do need to be a little bit more stringent on where death penalty fits in. Because if you have somebody dead to rights, that's my take on it, I guess.
My question, and this is behind Rudy's Fairing, by the way. Anna says, I missed who the caller is. Behind Rudy's Fairing. My question is, does that not just create a scenario, though, where the killer who is able to kill in isolation or to hide it well enough can't be convicted? Because we don't have that camera proof that we've come to depend on so much.
Well, you can still be convicted of life imprisonment, but I'm just saying raise the bar for the death penalty.
Okay.
Yeah. I'm not saying that. No, you shouldn't be convicted if you don't do it in isolation. But maybe if you're debating the death penalty issue, maybe a higher standard of.
Yeah, we might need more than 99%, right? We might need to be 100% certain before we.
Yeah, if you're caught on camera pulling the trigger,
it's interesting.
and
it definitely addresses the issue of what if we have the wrong guy, right? Because if we've got that 1% chance with the number of people that we're prosecuting, we're getting that 1%. We're including them in there. So
correct.
It's an interesting idea.
It's just something as the conversation's been going on, and I've been reading the chat. It's like, well, technology has changed. We have all of this stuff now, and so much of this stuff is actually getting caught on video or, whatever that standard would be. That's up to the lawmakers, of course. But maybe just raise the bar a little bit. We're like, hey, man, you're caught on camera. There's no denying that you were there and did this. Like, it's 100%. You're the camera is the witness. I just don't want to go down the slippery slope then of everybody's on camera 24/7. But let's face it, if you're in an urban area, act like you're on camera, because like I said, I was a retired firefighter.
Yeah.
When the police got body cams and they had in-car cameras and the photos, we had patients in the ambulance would videotape themselves in the ambulance. And people would go, well, that's a HIPAA violation. Well, no, it's their health. They're the one that's live on YouTube. You know what I mean? Yeah. We actually had patients do that. It's insane. But it is what it is.
It does seem a little weird. Chihuahua Mama brings up the AI factor, which if you haven't been following AI video creation technology, it has exploded.
Yes, I have.
It exploded to the level where you can get photorealistic reenactments of individuals using their voice and their image without them doing any of it.
Yeah, AI throws a whole nother wrench into the works. That is true. That is insane. Yes, I have been following it. I don't like it at all, but there's so much nefarious that can be used for. It's scary. Anyway,
great thoughts.
You have a great afternoon.
Behind Rudy's Ferry, thanks for the call. Appreciate it.
No problem, Scott. You have a good one.
We'll see you. Bye. All right. Let's see. How does that job even get posted to follow through on death penalties? Interesting question, Celeste Force. I once held in my hand the application that included those questions. It's part of the corrections officer's job to carry out the death penalty. I got an application for a state prison in a state that does have the death penalty, and on there's some questions, and they are disqualifying questions if you get them wrong. But one of the questions is, if you're basically instructed to shoot somebody, would you do it? The guards in the tower, they watch these high security prisons. They do have weapons, and in some situations they are authorized to shoot someone who's trying to escape. I haven't heard of that happening ever. Like, I haven't heard of somebody getting shot trying to escape prison, but it was on the questionnaire. And then also was information about, would you be willing to serve on say, like a firing squad? Where we have lethal injection, they have requirements for, and this is bizarre, you've got to be a doctor to administer the injection. Well, the doctor has sworn an oath to do no harm. So I don't know how they mentally do the gymnastics there. And to make it a little more just absurd, before we can execute someone, we have to first give them a physical to make sure they're healthy enough to die. So there's all sorts of conundrums that play in there. As far as palate cleansers go, Judge Wolf has something going on right now with a pro se defendant. Let me just see if it's still happening. I think it is. When did he come back from lunch? Oh, we've got somebody just kicked the tripod again. Let's see. Our pro se defendant had a elbow counsel, if you remember. See if I can get to it. Let's pause that for a second. That's the pretrial one we watched the other day or week. Yes, that's the same one. Do you want to go there, and we'll just keep the feed and the mic hot from Florida in case something happens. They keep kicking the tripod. I'm trying to figure out if people are coming back or what. Earthquake in Florida, maybe. Pro se guy is failing miserably. Is it worth jumping to? Should we jump to right after lunch? Because the jury had just got the instructions after lunch. Let's take a quick peek, shall we? Let's pop down to, let's see, box 2 would be 8. Pop down to Tennessee. Great state of Tennessee, where Judge Wolf is about to walk into the courtroom. Let me fix this audio. It's a little crackly.
All right, anything before we bring the jury in?
Judge, I wanted to address one thing briefly before the jury came in. When I read the indictment, I, of course, read it as would be anticipated for a bifurcated trial. So the defendant is charged with driving on revoked third offense, and I just wanted to be clear for the record that that was what he was pleading to.
It is clear for the record that the defendant is, in fact, charged with third offense, but because it is a bifurcated trial, I'm sure Mr. Spratt has probably explained that to you, Mr. Vaughn, but a bifurcated trial means under our rules, the jury cannot hear that you have been twice before convicted of driving on a revoked license. They only know that's your charge. So we will have the trial, and because on the third or the second count, but because you have been convicted of a driving on a revoked license, you have pled guilty to that, then it was a third offense. Is there going to be any contest about that being a third offense?
He's consulting his elbow counsel.
Because under the rules, what would happen is that we would have to have a bifurcated section that for the jury to determine whether or not you had 2 prior convictions.
Trying to get a different feed that doesn't have this crackle on it. Just 1 second. Camera 7. Let's see if I can switch to 7 here. Is that better? We still have the other court audio going in the background. As soon as something happens, we'll jump back over to the to Florida for a verdict if it comes in. Chihuahua Mama, this is my favorite court to watch. I call this the Heavenly Wood Courtroom for a couple of reasons. I used to work at a company called Heavenly Wood, and we actually sold pews and chairs and daises and podiums and lecterns and things like this. So basically equipment that would be used to outfit, say, either a church or a courtroom. And it reminds me of stuff we had in our catalog. It was a scam company. Don't buy from us. Just kidding. It was a weird job. I've got stories. Drama Llama Mama, Suno, S-U-N-O is what we have. This building is fairly new and nice. It looks new. I mean, the integration.
The state's got 2 witnesses. I'm not holding them.
Turn your microphone on.
I'm sorry. I think the state's got 2 witnesses, and
wait.
I'm not going to hold General Bryson to that, or Mr. Vaughn's not either, but before Corporal Stewart's testimony, we may have a short jury out.
Guess what? Took 1 hour and 24 minutes for the jury of 12 to reach a verdict in the trial of Jose Soto-Escalera. And this trial specifically is for the punishment phase only. This same jury has already convicted him in just a few short hours just last week, finding him guilty of 2 counts of first-degree murder for the death of Tanya Wise and her unborn child, Hosea.
All parties are present. I'm told the jury has reached a decision in this case. Before we bring in the jury, we tell those people in the audience here, regardless of what the jury's decision is, it's very important that people do not react emotionally to it. We have to remind ourselves of 2 things. Number 1, the jurors are conscripted to be here. They're not here by choice. And 2, is very much reflected in the proceedings in this case, where I've had to have 4 or 5 people arrested for not cooperating with the jury clerk's instructions to be present for jury selection. And those proceedings are ongoing. We have a difficult time getting people to participate and do their civic duty. If people were to react emotionally, it's going to affect the jury one way or the other, regardless of the decision, and that dissuades people from cooperating. So if you cannot control your emotions, you must leave at this time. I take this very seriously. I will put people in jail if they react emotionally. If you can't handle being here, do not be here for this. It is an emotional situation. And the reason is, as I stated before, my interest as a judge is to get people in the community to participate and be jurors. Anything that happens that dissuades them is taken very seriously. So you're welcome to be here, but if you can't handle the situation, please exit into the hallway and you'll find out what happened. All right, everyone's remaining with that admonition. Let's bring in the jury. We'll receive the jury's decision in this case.
So Tanya's mom and her son there on picture there in the black and white behind the prosecution. So Tanya's mom and Tanya's son there. So make that very clear. Jury's coming in. The judge said that, but I think the jury should have heard that. That he's that strict about that. The jury, last thing they heard was the defense telling them what awful people they are, and they're going to have to live with this mistake for the rest of their lives. $5 defense lawyer reacts. I don't think Jose will.
All right, the jury is entering. All right, Ms. Bickley, the foreperson of the jury, if you would please hand the jury's decision to the bailiff for my consideration.
We're outing all the jurors with this judge.
Shall we remain standing at this table, Judge?
Yes, please, actually. Let me review the verdict form.
We have a verdict, Mike.
You may be seated at this time. The verdict form is in proper form. The clerk shall publish the verdict, omitting the caption.
Defense lawyer says stand up.
As to the murder of Tanya Wise, we the jury find as follows. As to the defendant, Jose Soto-Escalera, aggravated factors. We the jury unanimously find that the state has established beyond a reasonable doubt that Jose Soto-Escalera was previously temporarily convicted of another capital felony. Yes. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of Tanya Wise was committed for financial gain. No. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of Tanya Wise committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes.
Is that legal
If
justification?
you the jury answer no to every aggravated factor listed, you have completed your deliberation as to count 1. We the jury find by a vote of 8-4 that Jose Soto-Escalera should be sentenced to death for the murder of Tanya Wise.
By a vote of 8-4.
Verdict as to the murder of the unborn child of Tanya Wise. Aggravated factors. We the jury unanimously find that the state has established beyond a reasonable doubt that Jose Soto-Escalera was previously convicted of another capital felony. Yes. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of the unborn child of Tanya Wise was committed for financial gain. No. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of the unborn child of Tanya Wise was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We the jury unanimously find that the state has established beyond a reasonable doubt that the unborn child of Tanya Wise was a person less than 12 years of age. Yes. If you the jury answer no to every aggravated factor listed, you have completed your deliberation. We the jury find by a vote of 8-4 that Jose Soto-Escalera should be sentenced to death for the murder of the unborn child of Tanya Wise, dated this 25th day of September 2025. Foreperson, Maria Pickles.
Please be seated. I will poll the jury this time. Ms. Busa, does the decision announced by the clerk accurately reflect the jury's decision?
Yes.
Ms. Sedano, does the decision announced by the clerk accurately reflect the jury's decision?
Yes.
Ms. Does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Ms. Decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Ms. Decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Mr. Fleisch, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Ms. Decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Decision announced by the clerk accurately reflect the jury's decision?
Mrs. Yes, Your Honor.
Ms. Holmes. Mr. Meek, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
And finally, Ms. The decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Thank you. Ladies and gentlemen of the jury, the decision of the jury is accepted by the court subject to further proceedings. It does conclude your service in this case. Before I release you, I want to instruct you of a very special privilege enjoyed by jurors, and that is no juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For centuries, our society has relied upon juries for consideration of difficult cases, and we have recognized for hundreds of years that your deliberations, discussions, and votes should remain your private affair as long as you wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although at this time you are at liberty to speak with anyone about the case or your deliberations, you are also at liberty to refuse to speak to anyone, especially in a case of this nature, of this magnitude, in a high-profile case. A request to discuss either your verdict or your deliberations may come from those who are simply curious, or from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere, and it will be left up to you to decide whether to preserve your privacy as a juror. Especially given your incredible time commitment and patience that you've had in this case, before I release you, I want to thank you so much for your time and commitment to this case. On behalf of the flags behind me, the United States of America, the state of Florida, thank you for your service. At this time it's complete, and at this time the ballots will assist you in leaving the courthouse. Thank you.
Mr. Escalera turns around to see that there is no one behind him supporting him. Part of that was because the process was so quick. Even some who came to testify, I don't know, was the lady with blonde hair, was she in favor of him?
All right. At this time, the defendant, of course, remains remanded in the custody of the sheriff pending further proceedings in this case. You maybe all be seated. With regard to the Spencer hearing and the sentencing, I have proposed timeline with some dates that are subject to the attorney's convenience and approval. For the Spencer hearing, I have the week of October 6th with Monday, Tuesday, and Wednesday, and Friday, which is October 6th, 7th, 8th, and 10th at 1:30 as possible times. And then my intent would be after the Spencer hearing on one of those dates at 1:30, the sentencing would be in early November 3rd, 4th, 5th, or 6th, which is Monday through Thursday at 9 o'clock in the morning. Did you all want to consult with your calendars and tell me what you think would be better for you?
Ms. Menden will answer for the defense.
Sure.
I'll go to it anytime.
From the state?
I'm good for any day on the Spencer hearing. My request, I have a date certain trial on November 3rd in Indian River County, the week of. Does the court have any dates available after that week?
Let's see.
This is like a pre-sentence investigation, I think, is a Spencer hearing. Is that correct?
If you just need to be in trial, Mr. Cormier could be here just for the sentence pronouncement, because there'd be no attorney involvement in that. So I really would not want to go later than that. I could go earlier than that, too. It's possible to go earlier than that, but that might be somewhat problematic. The reason I don't want to go earlier or later than that is, of course, my retirement is coming up. And as you know, as I mentioned, cannot work on this case whatsoever come the end of the year. So there may be some proceedings or administrative matters for me, depending on what the ultimate decision is in that time frame. So, and then when you say date certain in our business, you know, really date certain or not really? You know, date certain subject to last minute requests for continuance.
Is he trying to read his own palm?
Well, Judge Meadows set it for a date certain back in like June or July. And I've spoken to the public defender. It looks like we're both going to be ready. Of course, anything can happen.
And that's as far as the actual sentencing goes, that's really secondary because that could be adjusted. The first matter is to have the Spencer hearing. That's the most important aspect of this. You're looking at your calendar, Ms. Mint.
October 6th is good for me, Judge.
October 6th, 1:30?
Yes, sir.
Does that work?
Yes, sir.
All right, so let's go with October 6th at 1:30. And My suggestion regarding that would be, depending on what your request is, you could either get your arguments orally or in writing or both. If you are going to do them in writing, it might be better to get them to me a bit earlier than that, just so I can ponder them before I come to court if I have questions. But either way is fine. There's really no set procedure there. Also gives you the opportunity to present further evidence by the defense at that time. All right, anything else for us to address at this time until we come back on the Spencer hearing?
No, sir.
Mr. Richardson, do you want to address count 3 and 4?
There are 2 remaining second-degree murders from a previous information that was filed. The state will not send all process of both of those.
Okay. All right, we'll see you then October 6th, Monday at 1:30 for the Spencer hearing.
Yes, sir.
Thank you.
Thank you.
All right, so court will be adjourned until that time. That'll conclude our proceeding for today.
And we're done. Wow. Jury, on a count of 8-4, on a vote of 8-4, on both the count for Tanya Wise and for Josiah, the infant, unborn infant, unborn child, sorry. 8-4 in favor of death penalty. That's the minimum that's required to reach the death penalty in Florida under Florida's new laws that they changed after the Parkland shooter incident. They made it so it's no longer a unanimous decision that's required. So exactly 8-4.
No one down there?
And with it being so close, defense, and there goes Mr. Jose and his lawyer, defense must be thinking it was so close. How could I not reach one more person?
11 of the 12? There's no one from the jury clerk office to give them that, because that normally comes from the jury clerk. The jurors are asking for a work slip from the judge.
The jurors want their get out of work free excuse card. Victim's advocate there, giving a hug to Tanya's mom as the family leaves. No celebration. Obviously, there's no winners here. Although the state did get what they were asking for in death penalty for Jose. And with that, we are done. The microphones are the hanging things. That's correct. That's enabled us to at least hear some of what happened away from the microphones. I'm looking at the time. It is 4:38. I realize Judge Wolf is still doing his thing. As a matter of fact, if I went to him live, I might be able to show you. Let's see. There's Judge Wolf. He's right here. Is he still? Oh, he's stopped now. They just ended. I'm not sure if it's over or not. We might watch it tomorrow. What do you think? It's 4:30. I know a lot of you have been with us for a lot of the day. I've got to reprocess what happened with the defense closing. And you've got to think if, maybe he's saying to himself, well, I got 4 of them. Or maybe he's saying, if maybe I should have gone a different way and I would have had more people with me. Instead of attacking and insulting the jury, maybe I might have had somebody with me. But can you portal everyone to a courtroom in session? Angelique, I can only portal to channels that allow me to portal to them. So if you have a channel, you have to literally set up the channel to allow it. Let me check and see if Judge Wolf does. I'm pretty sure he doesn't. Nope. I need to redirect privileges. He'd have to grant it to me. He does not. If there's anything else on tonight, if there's anybody else talking about this case, particularly from the Law Tube, that you're aware of, let me know, because a lot of them will allow me to portal to them. It's pretty fresh. So some of our legal minds, Peter Tragos, Rob, Ian, a lot of them will probably want to digest it and review it a little bit before they go and give commentary on it. But if anyone has one of those, I'm not seeing it. I would say welcome to all those who joined us today. We had a lot of people join us because of Melanie Little and Broken Baker. Thank you to both the cupcakes and the muffins. So it was wonderful having all those. I think it was very pleasant to have so many new faces here. And welcome. Please join us again. It would be great. Rebecca's calling. Hang on one second. About to play the music, Rebecca.
Call from Bite Me.
Hey, Rebecca. I was about to play the music and your call came in. You're on the air. Is that cool?
Oh, hey, Scott. I'm sorry. I know you want to get off here. It's been a long day.
It has.
My head is swimming. It is just spinning round and round. But I saw AWOL's post right before I called, and I love AWOL. He is the greatest, and we should remember what type of community this is, and we do love each other.
Yeah.
And I was disappointed in the defense, the way they went about it. And my heart goes out to the families of both sides.
Mm-hmm. Victims on both sides, for sure.
Yes. There, like you said, there are no winners. They're all victims, and it's just an unfortunate, thing that there is no winners in this.
Yeah.
But I can understand how the jury voted the way that they did.
Yeah.
And I'm thinking if there would not have been a baby involved, that he may have gotten life without parole.
Yeah, I could see that.
But because
it would get rid of a lot of the mitigators.
Yes.
Or, not mitigators, the aggravators. Sorry.
Yeah, but because of that, and he knew that she was pregnant. That I think that's what did it for the jury.
Yeah.
A defenseless unborn child. So I don't know what else to say other than that. Other than you're the greatest.
Rebecca, thank you.
And Buttercup, as always, sends hugs and butter sugars.
Awesome. Thank you so much. I appreciate it, Rebecca.
She hasn't made an appearance in a while. I've been keeping my credit card under lock and key.
As you should. Thank you, Rebecca. I appreciate it.
All right. I love you, Scott, and I love chat.
Yep. Thank you. We'll see you. Bye.
Y'all have a good evening. Bye-bye.
All right. And with that, we'll give her the final word. I'll still get the final word, but we're going to wrap it up. Podcast tonight on this channel, 8 o'clock. All you have to do is subscribe. You don't have to, but I'd like it if you did. Subscribe, ring the bell. You'll be notified when we go live. 8 o'clock, join us. It's a live stream right here from this studio and from somewhere in Texas. Thomas is going to be joining us as well, bringing you some fun stories and some funny stories, as well as a few jokes, some laughs. Obviously, chat will be involved. You can come be part of it. It's a nice little break. A little palate cleanser. Just an hour out of your night. Please join us for that. It'll be wonderful. Tonight, when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again tomorrow. Or tonight, 8 p.m. I keep trying to skip the podcast. Tonight at 8 p.m. for the podcast. You guys be good to each other. Thank you all. Thanks to our amazing mods. Welcome all new people. Please stay a while. It's a lot of fun. Guys, we'll see you later tonight. Bye-bye.
There's nothing in the order that restrains you from talking to cats.
What more do I need to see?
Hush! I'm trying to have court. Don't raise your voice at you.
Thank you, sir. You're my new best friend. In front of the Walmart.
I don't like podiums, Your Honor.